All right, my friends. J.R. Dukes with you once again. Appreciate everybody joining me today. Have a great show once again for you. I am going to just quickly check, make sure we can hear one another on all the platforms. I appreciate everybody that has already joined. We are going to be going to the hearing that happened today involving Ashley Merchant. Of course, she's the attorney representing the defendant in the RICO case by the name of Michael Roman. We've talked about him and her extensively. And of course, all these investigations are really gathering steam, to put it bluntly, against Fani Willis and her office and the malfeasance that seemingly keeps coming day after day. I mean, really, it's this case is the gift that keeps on giving. I really don't know any other way to say it. It just seems like there's just more to be learned every single day. So it looks like we're having good audio so far. Just a couple housekeeping things that we're going to jump right into it. Let's see here. Okay, first of all, if you are joining us, go ahead and introduce yourself. Let us know where you're from. Danny, I appreciate you joining us right out of the shot here. Thanks for everyone joining us. Okay, we got, as I just said, go ahead and introduce yourself, say hello. And of course, Danny pointed out to me that yesterday we did have a slight issue with the sound. And to be perfectly blunt about it, I was thinking about not even mentioning the situation because it's a little embarrassing. Now, if it's the computer that messes up, well, that's not my fault. However, yesterday I did not even know that the audio was not what it should be. Without boring you with the details, when it comes to the software with StreamYard, you have to use a Chrome browser in order to make it stream properly. And the same thing is true with me. And to make a long story short, I was doing a screen share instead of sharing the Pacific tab for the video. Now, if it's a newspaper article or something like this and it's just me talking, it doesn't matter. However, if I want the sound to come through from a video to you, it has to be via the sharing that Pacific tab. It's real technical. However, I don't anticipate I'm making that mistake again. Again, I do apologize. I will say the only benefit that I could see to that happening is a few of you made comments to me pertaining to former President Donald Trump. And it was kind of a unique insight to watch him without the sound, because someone made the comment how he has a presence, how he commands the room just by the way he acts with just his signals. What do they call that? Body language that he gives off. And it's really spectacular to notice that. So I try to always find the good in everything, and we'll just let that go on the good column for that little mess up last night. I guess the good news, yesterday's podcast was rather short, and I did talking most of the time instead of listening to video or whatnot. That's not going to be the case today, because we are going to drill down on this Ashley Merchant case. So one other thing too, I'm going to put in the chats that if anyone wants to, well, the instructions for joining me live are there. I included the actual instructions from StreamYard in case you're interested. And I have also provided you with my phone number right there. It's just a text number, voice number. Obviously, I cannot talk at this time, but if there is a comment or something that I need to address during the live stream, go ahead and feel free to drop me a text at that number. I do have my phone here, and I will monitor it if anything like that was to develop again. The other way, I'm going to make sure that this does not happen again, or at least try not to allow there to be a problem, let's just call it that, is when I see someone comment that there is a problem, I'm not going to just ignore it. Because if I'm being perfectly honest with you, sometimes I think there's individuals that don't know how to use their computer, or maybe I'm thinking they hit the wrong key because they're the only one saying anything. And in my mind, I'm thinking, hey, there's 2, 3, 4, 500, 1,000 people, whatever, in this particular chat, and no one else is saying anything. So it must just be their computer. I will not be so presumptuous next time. I will pause and see what's going on. Also, I have another iPad here on my desk, and I keep the volume down so it doesn't loop into the mic right here. But what that's going to help me with is I can make sure that there is sound. So hopefully we will not have that issue again. All right, so enough of the background stuff. There's my information right there. It's in the stream. The link, if you'd like to join the conversation, is right there. Just go to the chat and click on it. I will send that through Bitly and get us a shorter link next time, so that it is it's not something that you have to find that link. That's a little bit too problematic to be blunt about it. This link right here from StreamYard, this is the link to click if you would like to join the chat live. You'll pop up on my screen here, and then we can add you accordingly. So, okay, so let's get into it. What's going on today? And Daniel, welcome. Happy hump day to everyone. Danny, I already said hello. I'll say hello again. All right, so today was one special day. I'm not one to brag on something or try to hype it up too much. This hearing today was phenomenal. The players in today's hearing have to do, of course, with big, sweet, I call her sweet Fani Willis. Donald Trump always gives people names. I'm going to start giving people names. I'm going to call her sweet Fani Willis. I don't know why that name pops in. Because obviously I'm not being serious concerning her name, but sweet Fani Willis is all that I can think of. If you have a better name for her that I can say in a public situation like this, go ahead and let me know. However, I have also mentioned that the cases against Fani Willis, DA Fani Willis, DA's office, Nathan Wade, all of them are ever increasing. It's just that simple. The volume that I have, I've already counted. I think I have 16 or 17 separate causes of action. We'll just let it go like that. As a matter of fact, I believe tomorrow there are 2 ethics complaints that are going to be heard against DA Fani Willis at the Fulton County Board of Commissioners. That are 2 separate situations filed by 2 separate individuals. And I'm going to drill down on that heavy, and we will hopefully talk about that more tomorrow. So today you have a Senate committee. Now, this is the state Senate, the Georgia State Senate. This is a special committee put together, made up of Republicans and Democrats. So it's a bipartisan commission. Their entire focus is on these types of matters. It's basically called a special investigation committee. But whatever you call it, today I'm going to call it exciting, because Ashley Merchant really brought the goods today. And you know how, like, we have speculated about a lot of things that might have happened in this case, and why did Terrence Bradley do this or do that, or how did Ashley Merchant get the information to get this ball rolling? It's all being laid out today in extreme detail. And I'm telling you what, literally, when I was listening to what I was able to listen to earlier today, my mouth was hanging open. I was like, wow. And I'm telling you, it's going to be worth the time we're going to spend together as much as you possibly can. So let's go ahead and start taking a peek at it. Here we go. All right, this is the actual hearing. I'm going to minimize myself. I am going to try not to have a ton of talking over this, because I want you to hear exactly what is transpiring. But at opportune times, I will interject and make sure we're clear about a few things, because I don't want anybody to get lost, because she is going to take a deep dive on this, but it is worth the time to listen to this. Again, if you have any questions, go ahead and put them in the comments. I will try to moderate via comments below while we're live streaming. And if I'm able to do that without having to interrupt, I think I'll just keep dumping it into the comments. But don't be afraid to ask a question or make a comment or whatever it is. So anyway, if you haven't done so already, please hit that thumbs up button. It does mean a lot to the channel. It helps the algorithm push this out to other people. I've heard for every person that likes, they push it out to 7 other individuals as far as seeing it on their screen. I guess an improv or whatever the terminology is they use to categorize it. Okay, so here we go. I'm going to make sure we got sound, so don't fret. Here we are.
Committee members, Senator Hatchett and our minority leader, Gloria Butler. I think they're both en route, but we do have a quorum, so we'll call our meeting to order. This is the Senate Special Committee on Investigations. We have issued a subpoena on February 28th, and that was issued to Miss Ashley Merchant, who has been in the news quite a bit lately and had apparently quite a bit of documentation that we thought would be of interest. We also subpoenaed her to testify before the committee this morning, as is permitted by our rules. Ms. Merchant responded to the subpoena, and as required by Monday at noon. And the Secretary of the Senate, Mr. David Cook, has all of the documents produced, and he will keep those in his safe room, I guess we'll call it, David, his repository. I can see you've got a couple of banker's boxes full of records. These are available for any committee member to review at your pleasure. Just get with Mr. Cook. We are keeping them under lock and key, so to speak, so they will not be made available to the public until we determine whether any of them involve confidential information or not. So we'll have those available. The Minority Whip took some time last night, and I think he may have been the first person to really review all of the records and spent a few hours there in the Secretary of the Senate's office to review this information. I'm going to make a determination after we have heard this testimony and heard from Ms. Merchant as to whether or not some or all of those documents will remain confidential. I remind the committee members, in our rules, you are bound to confidentiality unless things are publicly disclosed. So for now, we will be reviewing some of the documents during this testimony. But I will ask you, Ms. Merchant, to let us know if anything, in your opinion, is confidential that you would not like for us to publicly disclose for whatever reason. And then I will review the records as well. There are some personal financial records in there that I'm not comfortable at this time disclosing those publicly. But just to sort of set the ground rules here, I will conduct the interview with you. You will be sworn under oath. Miss Brenda Elwell is our court reporter. She will be making a transcript of all the proceedings, and that will be publicly disclosed for the press if you want to go back and double check and see exactly what was said. That will take a couple of weeks to prepare that transcript, but this meeting is also being live streamed, so it should be easily accessible to the public and anybody interested in this. I'll begin. Ms. Merchant, you are here under a subpoena to testify. I'd like to go ahead and swear you in. If you will please raise your right hand. Do you swear that the testimony that you will give before this committee will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
Right. So, well, if you will just continue with the transcript as we go. If you get hung up at any time and I fail to hit the right microphone and you can't hear who's saying anything, let me know. The way our procedures work is that I will be asking the questions and minority party will have an opportunity upon request to ask questions as well. I've discussed this with the Minority Whip, Senator Jones, and he may or may not ask questions towards the conclusion or maybe even at a break. If you want to, just let me know. Ms. Merchant, would you please just identify yourself and let the committee know? You see all our name tags to see who's on here. You know who we are, but let us know who you are and what your profession is, background, et cetera.
Definitely. My name is Ashley Merchant. My first name is Ashleigh. Last name Merchant, M-E-R.
You're going to need to pull
They're gonna
that
fix her
microphone a little
microphone
closer
at one
to
time.
you.
Thank
So-
you.
Is it okay? I have a notepad just in case
You're
I get
absolutely
two
free.
questions at the same time. I like to make a note to make sure that I remember.
The committee knows the rules. We passed them unanimously at our last meeting, and you actually have the right to counsel if you want to. It's not like a court proceeding where we're going to be having objections, et cetera. But since you are an attorney, apparently you're very comfortable responding. Okay,
Yes.
didn't mean to cut you off. Let's
That's
just
okay.
make sure everybody can hear you there.
Thank you. Yes, I'm a criminal defense attorney. I was sworn in as a member of the bar in 2004. So I've been a criminal defense attorney for 20 years. I started out when I first graduated from law school. I came to Atlanta and I did an externship with the Southern Center for Human Rights. And then once I was sworn in as a member of the bar, I became a public defender in Fulton County. I was there for 4.5 years until I started my private practice, the Merchant Law Firm. We had an office in Fulton County at first. Now we're in Cobb County. I'm in practice with my husband, John Merchant, and we do criminal defense primarily.
And do you have any other roles or affiliations? I've seen just press articles about you.
Yes. Yes. So I do. I've been very blessed to have a lot of active roles in the community. I was the former president of the Cobb County Bar Association Criminal Defense Section. I was sworn in January as the president of the Georgia Association of Criminal Defense Lawyers. I've been a member of that for 20 years, member of the Cobb County Bar Association, very active in both of those roles. I've been honored with several different awards, one from the Cobb County Bar Association, Defender of Justice, or Champion of Justice, I'm sorry, a couple years ago. And then, I've been honored with Rising Star Awards, Super Lawyers, and the Daily Report has different awards back when I was younger, 40 under 40. Wouldn't qualify, unfortunately, for that anymore. But, and then recently I was awarded at our annual meeting for the Georgia Association of Criminal Defense Lawyers. I was very honored to.
She has a list of accolades. Y'all know how much I absolutely adore Ashley Merchant. In addition, the recognition by the Fulton County, what they call the Daily Reporter, that's the legal organ in the state of Georgia where everything legal is generally publicized, including anything to do with attorneys. So it's another accolade for her and a good accomplishment that she's proud of.
To receive award about my work defending the Constitution.
Okay. So you are the current president of the Criminal Defense Lawyers Group.
Yes, yes. And it's the Georgia Association of Criminal Defense Lawyers. We go by GACDL. We have about 1,500 members right now. We're aiming to get around 2,000, but we're one of the largest defense bars in the country.
And tell us a little bit about your trial experience over these last 20 years.
So I started doing post-conviction work, which is, after a person is convicted, doing appeals and habeas work. Then I went into misdemeanor trial work at first when I was a public defender. I moved into the complex felony division, which is where the majority of my practice has lied. I do about half of my practice is appeals, appellate work in the Georgia Supreme Court and the Georgia Court of Appeals. The other half is trial work. I specialize in complex felonies. So anything that's mostly in Superior Court. Every once in a while, I'll have a client who has a state court case, and so I will end up helping them on that, but primarily complex felonies.
All right. And during the course of your practice here in the Atlanta area, tell us a little bit about your involvement. And I'm just going to refer to these as the election interference cases. I think there's 16 or 17 defendants. You are involved in those cases, I know from seeing the news.
Yes.
Who do you represent?
I represent a gentleman named Michael Roman. I was hired late August, early September, around, I think it was late August, to represent him. He lives out of state, does not live in Georgia. Yeah. But so I've been his defense attorney since the time of indictment.
All right. So late August or September of 2023.
Yes. I began working on his case in late August of 23. I think I looked this morning, I filed my official entry on September 1st of 23. And then I negotiated bond for him, walked through the turn-in process and began negotiations with the prosecutors.
What exactly is he charged with? What's the offense he's been charged with?
He's charged with conspiring to violate the Racketeering Act, so RICO. He's also charged with some of the more specific allegations for him are attempted and conspiracy to file false documents. So essentially, I've classified the indictment. The easiest way for me to classify the indictment is there's the folks that are federal officers. There's the folks that are charged in the alternate elector process, and then there's Coffee County. He's in that middle section.
So that's the alternate elector process.
Yes.
And those are the documents that are deemed to be false. They're
yes, that's what he's charged with. He's charged with false, filing false documents, false swearing, things like that, forgery.
And to be clear, you do not represent any of these alternate electors.
No, I only represent Michael Roman.
And you don't represent Donald Trump.
No, I do not represent Donald Trump.
Your involvement in the case is just for Michael Roman.
Yes, exclusively Michael Roman, and that's my duty.
You have produced quite a few documents to us.
Yes.
Do you have any concerns as to whether any of those documents are protected by attorney-client privilege?
I don't have any concerns about that. I do have some privacy concerns because you mentioned earlier that there was some financial documents that are not redacted, and so those would need to be redacted. That would be the only thing, but they're not. Phone numbers, I believe I redacted all the phone numbers, but there are some financial documents that are probably sensitive.
Okay. As far as Mr. Roman is concerned, is he giving you permission to speak freely about his case and about the evidence or documents you've accumulated in the course of his defense?
Yes, we went over the subpoena that I received and the classification of documents that I was asked to give. All of those were things that I obtained through discovery, not discovery from the state, but through my own. So we have a protective order in the case. So anything that I've obtained through the state could potentially be subject to that protective order. But these were all documents that I obtained through my investigation.
Okay. Most of the members of this committee are attorneys, but not
Okay.
all.
Okay.
And I recognize that the general public will be hearing some of this or either now or later. Tell me a little bit about when you're talking about states discovery. What do you mean by that? I know, but
Right.
everybody else may not.
Yeah, definitely.
Yeah.
So we have a statute in Georgia that allows us to do what called opt-in. So if we opt into the discovery statute, that means we're engaging in reciprocal discovery, which means that the state has to give us a copy of all of the material that they plan on using at trial. They also have to give us copies of anything that would be arguably exculpatory. And so in this case, there's been a lot of discovery exchanged because obviously there's a lot of defendants. And if they wanted to classify something as sensitive, they would do so. And then if we wanted to be able to disseminate it to any third party outside of our practice, we would have to have court permission to do that.
Yeah.
But when we are investigating a case, not everything comes through discovery. So in general, I would investigate a case on my own, and those items are things that I did not receive from the state. So we've got different classes of documents, the documents that I actually received from the state through discovery, through formal discovery, and then documents that I developed on my own.
Okay. And out of these documents that you've obtained from the state through formal discovery, that they're obligated to provide defense attorneys to fairly defend your client. Some of those have been deemed to be sensitive and that are not freely disseminated?
Yes. The state, how the protective order works, and the protective order is public. It was publicly filed. If the state deems something sensitive, they let us know that. And if we dispute that or we have some reason that we want it to be able to be disseminated, we would have to go to the court and basically argue over that.
Fair to say any of the documents you have provided to our committee were things that you obtained outside of that formal discovery process and are not subject to any protective order?
Yes, I did not. Nothing that was subject to the subpoena or that I provided was something that I got from the state.
Okay.
And nothing was subject to that protective order. I went through and was very clear on that.
Okay. And I'm wanting to make sure of this because this committee has made it clear from the beginning, it is not our intent in any way to interfere with the criminal prosecutions. And so I would not want to be circumventing a court order that was for the protection of the privacy of the parties to that case. It is not our job to interfere in that case at all or in your motion to disqualify Ms. Willis.
I appreciate that. And I was very cautious because I certainly don't want to go against a court order
Sure.
protecting. So I did not disclose any of those documents.
So tell me a little bit about the special grand jury process. It sounds like that occurred before you were ever even hired in this case.
It did. It occurred, and my client, Mr. Roman, was not involved in that at all. So he was never someone that was issued a target letter or a subpoena or contacted. So he was never involved in that either. So he didn't have counsel, obviously, since he was never involved in the special purpose grand jury. But in my role defending him now, I've obviously reviewed all of the things that happened with the special purpose grand jury that I have access to. So it's my understanding Ms. Willis obtained an order from, at the time, it was Chief Judge, I believe it was Judge Brasher, who was the chief judge at the time, obtained an order to impanel a special purpose grand jury. And I followed that in the news before I was involved in the case because it's very unique. It's not something that happens very often. Normally when we see a special purpose grand jury, it's some type of investigation into a jail or something like that. So it was kind of unique to see that. But from reading everything, my understanding is a lot of the witnesses weren't willing to necessarily talk without a grand jury. And so that's one of the reasons that they had to impanel a special purpose grand jury. But it was very unique.
I've been practicing here a long, long time, and I haven't seen a special purpose grand jury to basically advise the DA, apparently, or a subsequent grand jury as to whether there's evidence to prosecute. Is that essentially what it did?
That is exactly what it did. Yes. So, and now through the discovery process, I've been able to review a lot of the transcripts and also talk with a lot of the lawyers who were involved and witnesses that were involved in the special purpose grand jury. But that's what they did. They used that process to subpoena, particularly out-of-state witnesses. So in Georgia, it's always difficult when we have a witness who's out of state because we have the interstate compact. We have to get a certification to get a witness subpoenaed from out of state. It is not easy. It is one of the more difficult aspects of our job. So they use the grand jury process, the special purpose grand jury process, to bring in testimony and bring in, witnesses from out of state. They issued a lot of target letters to people back and forth. There was a lot of people that were targets and then weren't targets, who testified, maybe negotiated some type of immunity, things like that, throughout that special purpose grand jury.
Okay. And is that made public to other defense attorneys if immunity has been granted to any witnesses?
I don't know if it was made public originally. I know that some of it has been provided to us through discovery. We had a motions hearing where the judge ordered that the state give us copies of transcripts because they had everything recorded. So there's a transcript from the special purpose grand jury. It's my understanding there's a transcript from just about everything, but it does appear like sometimes that was cut off. So there are some sections that were recorded and then maybe a section wasn't recorded and then they went back on the record. But it was recorded, which we rarely get in a regular grand jury. We rarely, if ever, get that type of testimony. So that was very unique to have.
Is the state required to let you know if they've granted immunity to any witnesses that may have been utilized in the special grand jury process or in seeking the indictment?
Yes, they are. And, some of that has been given to us through discovery. Some of it has been given to us from other attorneys, the attorneys who maybe represented those parties. There was a lot of back and forth. There were a lot of, and this, I believe this was all public, that some of our state representatives, I think the governor in particular, were subpoenaed, and there was back and forth over who could grant immunity, who had the power in that office to grant immunity. And that's something that I reviewed in my work on this motion with the DA's office, because Mr. Wade was the one that took over that power. And so the emails that were attached to a lot of the pleadings, it was interesting. It first started out that there was someone else in the DA's office who's actually an employee of the DA's office who was negotiating all of that. And then it evolved to another member of the DA's staff. And then ultimately it was Mr. Wade. And there's emails where he said, I'm the only one that can grant immunity. I'm the only one that has the power to do this. I'm in charge.
Was he engaged or involved in the special grand jury process?
Oh, very much so. He was by far the lead of it.
Right. And do you have the timeline of when that special grand jury was authorized and when it began to meet?
Yes, I don't know the dates off the top of my head, but there is an order and I can review it. I brought some of the pleadings with me, but it was authorized sometime. So he was appointed, the timeline, he was appointed in November 2021 to work on this case. It was sometime after that Ms. Willis sought the special purpose grand jury and got authority to do that. And then that went through, several months, and then they issued a report to her.
So he was hired by the Fulton County DA's office before the special grand jury was authorized or impaneled? Okay. And so he was involved from the very beginning of that process.
Yes, and he was actually hired, I believe, before it was even, I know it was before it was impaneled. I believe it was before the order was even issued, though.
And do you know what his role was as what's the official term? A special assistant district attorney?
It's a good question. I'm not sure. He usually goes by special counsel or special prosecutor. I don't believe he goes by special assistant district attorney. I don't think he's permitted to do that. I've studied these statutes a lot, and there's no real term for it. I've heard him go by independent counsel, things like that. But I don't really think independent counsel would be an appropriate term because he's not independent. So I've studied, I did not know this before, but I've studied, the structure of the independent counsel in the federal system. They're actually a separate office. They have their own appropriations to have a separate office, and they are kept separate from the U.S. Attorney's Office. So that would be where you get the independent counsel term from, or independent prosecutor. He goes by special usually, so special prosecutor or special counsel. And I think that's because he's not independent.
Is this commonly used in the state of Georgia? I don't know the scope of your practice. I'm not familiar with DAs doing this often.
No, and so I do practice throughout the state, and I've practiced in almost every county in the state at some point in my career, and it is very rare. I've had instances where there is special counsel, but those are very limited, and I can tell you about those. And then I can also tell you what I did to investigate that, because I had the same question. So first,
Just so you'll know why we're asking, the scope of this committee is we've heard a lot of the allegations, and you, as a matter of fact, made most of them, or made
Right.
some of these public. And there's, of course, a public, outrage or uproar or concerns about some of the alleged improprieties that you brought forth, both, within the in the system, kind of what's appropriate conduct,
right.
and also financial improprieties. And we're tasked with investigating and finding the true facts, and not just taking the press at face value. And that's why we're asking you for documents, et cetera, so we can independently verify the various allegations that have been made. But we're also specifically tasked with, if necessary, amending existing statutes,
Right.
or creating new statutes to build guardrails or whatever to essentially restore the public faith in our criminal justice system, in its impartiality and its fairness. And I have looked at some of the existing statutes, but it's very sketchy. What is the real authority? And we wonder if we need statutory authority or statutory limitations. And so I'm going to explore with you a little bit what the authority is for a special grand jury to be conducting a criminal investigation, and also the use of a special assistant district attorney is what I'm referring it to. But and so that's the context. You have done that research, so help walk us through this just a little bit. Is there a statutory process that gives authority to utilize a special grand jury to advise a DA, or to essentially accumulate evidence for a DA to determine whether or not to indict?
Right. So the first question was about whether this happens throughout the state or not. I did do open records to every single district attorney in the entire state of Georgia to find out, because I wanted to know, I knew based on my practice that it was a very rare process, but I wanted to know, I wanted the data. I wanted to actually see it. So we did an open records for every single district attorney. We have received responses from almost all of them. There's only a couple that we haven't, but I don't know that those would be big factors. The few that were remaining, I think it was Augusta that I haven't received one from. But I talked with two of the prosecutors in those districts. There's only two that actually use something that would be akin to this. And one of them said they haven't done it in years, but they have done it. And they pay between $40 and $40 an hour, which tends to be about the going rate for appointed counsel. It's between $40 and $60 an hour, I know, for appointed counsel in most counties. And then the other county that did use them, they use a part-time solicitor. And that DA said every time that they would have maybe some overflow work, an appeal or something that they had extra work to do, they would hire this part-time solicitor. So it was someone who was already a government employee, and they would pay $45 an hour for this person to do work. So those are the only people. This is a very unique to Fulton County, which I assumed, but I didn't know until I did the research. Nobody does this but Fulton County. And the AG's office does it. And so we got a lot of arguments from the state about, well, the Attorney General's office does it, but that's a whole different statute. It's not even the same section. So the Attorney General is authorized because they represent all of the state agencies. They are authorized to hire outside counsel, and they have to because there's a lot of conflict issues. And so it makes sense. So you've got different needs for hiring outside counsel. You've got conflicts if there's a conflict. And if there's a conflict, you'd have to hire someone who's outside of the office. You couldn't hire someone like in this case, like Mr. Wade, to be special counsel because they're in the office. So you can't, when you have a legal conflict, you have to have the offices have to be separate. So with the AG, that's usually what happens. Sometimes it's specialized knowledge. I mean, you've got people who are representing commissioners, you've got people who are representing, people in certain agencies in the state, in certain types of power. And so it might be a specialized practice area. So the Attorney General is authorized, and they actually publish it on their website, all of the rates. It's very transparent. So I went through and looked at everybody's rate. I mean, it's very transparent. How much they pay, it's based on experience, They get approval for that. They get approval for the appropriations for it. And it's just extremely transparent, which is in direct contradiction to how it works in Fulton County.
And do you know how many judicial districts we have in Georgia? I don't.
I do not. I could look at my open records request. So the judicial districts, there would be a district attorney for each of those. And so those are who I sent all of those.
It's over 50.
It's over 50. I think it's 59, but I'm not positive.
That's what I think.
I think it's 59.
So out of those 59, you reached out to all of them to see if their district attorney's offices for each judicial circuit ever utilized a special assistant, outside counsel.
Yes.
Okay. And out of those, only 3 of them have ever done it?
Only 2.
Only 2.
Only 2 had ever done
Fulton
it.
County is one of them.
Only 2. Well, yes. I'm sorry. It's 3 counting Fulton County.
Okay.
I did not send an open records to Fulton County on that because I already knew that they did it.
Is there a statute that authorizes that?
There is a statute, and I cite it, if I may, I cite it in my brief.
Feel free.
Okay, thank you. I don't want to misquote it. Let's see. So it's 15-80-20. And how I came to learn that is I actually contacted the prosecuting attorney's counsel early on in this case. And because I was trying to figure out the legality of this, I did open records and I found out how much money the special counsels in this case were being paid. And there's about 20 different people in Fulton County that are paid under this type of arrangement. It's the largest personnel budget item in the DA's office.
Why wouldn't you just hire more assistant DAs and have them in-house?
That's what I didn't understand. And that's what, I mean, in my opinion, obviously, I think that's what should happen. But the reason that it wouldn't happen is because if you're hired as an assistant DA, you can't take private work. So the statutes, and they're all in section 1518, 15-18, the one that gives the authority for this is 20. But all of those, if you read all of them, it makes it very clear that if you're going to hire more assistant DAs, they have to be paid the statutory rate. So you can't just pay an assistant DA anything you want. You could not pay them $300,000, something like that.
What is that statutory rate?
I don't know it off the top of my head, but it is in the statute. I know that like District Attorney Willis, for example, I think it's around $200,000, and that's one of the top paid people. So most of the people are paid, somewhere between $100,000 and $150,000, something like that, depending on their role, depending on county supplements. So what the statute says is it gives a state salary, and then you can get a county supplement. But all of that is around that range. I'd say around $150,000. But there's limitations. So to answer your question, why you wouldn't just hire an assistant district attorney, first, they couldn't make as much money as independent counsels, or I'm sorry, not independent, special counsels, couldn't make that much money, but they also would be limited in their law practice. They wouldn't be able to have private practice, and that's by statute. So if you are hired as an assistant DA, you cannot have a private law practice also.
Do you know how many there are in Fulton County DA's office?
How many special prosecutors?
No, how many assistant district attorneys?
No, I actually opened records that, and it was declined. So we actually have a pending open records lawsuit, which I did bring. I asked for that. I asked for how many were hired, when they were hired, when they were fired, and they declined to give me that under the Open Records Act. So we ended up filing a lawsuit, and that's still pending. Because
it just occurs to me, I think there's certainly dozens of them.
Yes.
Maybe 100.
I think 100 would be a fair example, or a fair number based on just my knowledge of it. But there's quite a few, and if you had a certain amount of money that they spend several $1 million on these special prosecutors, that could be spent on a lot more assistant district attorneys.
That's an interesting point she's leading to. The reason, in part, Nathan Wade might have been hired as a special prosecutor versus a straight up assistant AG is because he could not have a law practice otherwise.
Do you know the process in Fulton County on how you approve the budget for the DA's office? Is that something controlled by the county, or does the DA have total discretion?
It's controlled by the county. And I do know, I actually went back and watched a lot of budget meetings. They have their budget meetings online. I read a lot of the transcripts. And so it's very interesting. It's kind of a long answer though. Depending on who you are, in Fulton County depends on how your budget is approved. So for example, the county attorney, if they want to hire special counsel, okay, and pay them hourly, like in this case, they go and they get that approved at the county level. They actually appear in front of the county Board of Commissioners and say, we need to hire this person at this rate, and they approve the rate. They monitor the bills. They do all of that stuff. So that's what happens at the county attorney's office.
Okay, the county attorney represents the county, is not prosecuting criminals like the DA does.
Correct. It's civil. So the county attorney does all civil things. In this case, they actually did end up representing the DA in some of the open records issues, which is a whole nother issue. So the county attorney, the civil body, they actually go and get county approval from the Board of Commissioners. And there's actually a resolution. So I think I attached as an example in one of my briefs, a copy of a resolution just to give as an example. I'm pretty sure I did. And it's very transparent. They get it approved. Yeah, here it is. It's called a resolution, and it's a resolution authorizing funding for additional personnel. And basically they go and they say, we need this for this project. We need this budgetary item, and it's approved. It comes out of their budget though. So they're not going and asking for more money for the county attorney's budget. They're just asking to use the county money that they've already been allotted for this special counsel. The district attorney has taken a different position. And I was surprised. So I watched hundreds of hours of Board of County Commissioners meetings just to make sure that I wasn't missing anything, that she never went and asked for approval for any of these special prosecutors.
Her budget is granted through the Fulton County?
It is.
It's in part of its budget?
It is. So these special prosecutors have been paid a couple different ways. They were paid with state seizure money. So the first, around $100,000 of Mr. Wade's funding came from state seizure money. It appeared from looking at the budgets for the state seizure that fund ran out. So then it started coming from the general fund. But it was money so Ms. Willis had a budget right around the time that she hired Mr. Wade and these other special prosecutors. She went and asked for more money for a backlog. And so she was given extra money, and that money's been renewed since. It was given to her to hire 55 additional personnel, and it's actually in the resolution. She went in front of the Board of County Commissioners and asked for it.
When was that? Do you know?
I do actually, because I attached it to my brief. So I know the dates of things. September 15th, 2021. Is when she presented her PowerPoint to the Fulton County Board of County Commissioners. And she gave a lot of statistics about all the unindicted homicides. It was mainly about homicides. It is, there was some about sexual offenses, but it was almost all about homicides. She said that, why am I here? The great trifecta: crime is on the rise, historic mismanagement, and then the COVID backlog. And so she asked for quite a bit of money to hire additional personnel. It was, I can tell you, that year it was $780,000.
And that's in the fall of 2021, just before this special grand jury was impaneled?
Yes. So that happened. She was awarded that money September 15th, 2021. And she actually did get the resolution and the process that you would normally expect.
How much was that addition or increase to her budget?
Not to exceed $5 million.
Wow.
So she was awarded for the end of 2021, which this is September 15th. She was awarded for September until December 31st, $780,000. It said, and then the next year, not to exceed up to $5 million.
So hang on for 1 minute. My vice chairman here, Chairman Dolezal, is way more high-tech oriented than I am.
Okay.
He has downloaded some of your documents that you produced to us that I had asked him to have available so we could see them here. And I think you have produced to us this PowerPoint presentation that Ms. Willis made to the County Commission in September of 21 to allegedly fund backlog of murder cases, et cetera.
Yes,
right? Okay.
That would be Exhibit A to that motion. Yes, that's it.
And is that what we have on the screen here? Let's see if we can flip this one right.
It is.
Okay, so this is part of her PowerPoint presentation for additional funding over and above her previously appropriated budget from the county?
Yes. Yes, it is.
Okay, all right, so what were the county procedures for approval of funding for, additional outside counsel, or in this case, it sounded like she was going to hire 55 people in-house to help
Right.
with the backlog. Does the county have guidelines or rules or regulations as to how you get funding approved for either additional staff to work on her backlog of homicides or for special counsel to assist you?
Oh, yeah. Yes.
What are those proper procedures?
You have to get approval by the Board of County Commissioners. And the statute that I cited originally, 1820, that statute actually is the one that it says that you can hire additional personnel like this, but it has to have county approval.
Okay.
So, I mean, the statute says it already. When you were asking about changing statutes, I mean, it's clear in the statute that it has to be approved by either local law or the governing authority, which would be the county in this place, and in this instance. And it's very specific that it can't be paid with state funds.
Anything in that September 15th of 2021 proposal or request for funding that addressed or contemplated special counsel to pursue indictments against folks for election fraud?
No, not at all. And I watched the video. It's online. Her speech where she used the PowerPoint in the speech. There's nothing about that at all. And in fact, what was submitted was pretty specific. It was to hire 55 new employees, not contractors, employees, in November 2021 and December 2021. And I did open records based on this, asking who was hired and the dates of hire, because I wanted to be able to track that, and that was denied.
And who made that denial, the DA's office or the county?
The DA's office. And I did bring the open records lawsuit just in case you had any questions about that. So it was the county, and I can tell you when I filed it. Let me see. And we went back and forth, and I requested it several times, but it was Dexter Bond at the DA's office who sent a letter back and said, we don't have that. We don't have to give it to you.
He's like the chief assistant for Fani Willis.
He is, and he's also the one who went to the Board of County Commissioners whenever they needed funding. So, if they had some large printing, and they had a big rebranding campaign where they had a lot of money that was spent on this rebranding, like posters and things like that around the office. And he had to go and testify in front of the Board of County Commissioners to get that paid because they were not paying it. So he's sort of the go-between with the Board of County Commissioners. His official title is something like Chief Legal Officer or something like that. But he's an attorney.
So you've gone back and reviewed all of the Fulton County Commission's minutes and records to see what requests were made and if there was a resolution granting the additional funding?
Yes. Oh, yes.
Was there ever a request for additional funding for a special prosecutor to pursue these election cases?
No, there wasn't. And I knew that before we got the district attorney's response, but subsequently we got a response from the district attorney's office that said, we didn't do it. We don't have to do it. I'm a constitutional officer. So their argument was, we don't have to comply with those statutes or those rules because she's saying she's a constitutional officer, so she doesn't have to get county approval. She can spend her budget however she wants.
Then why would she have gotten county approval for the other 55 attorneys?
So what I've surmised is that was because those were staff members. And so she went and asked for additional budgetary money. She needed a higher budget. So for those 55 people, she went and asked for more money because she didn't have enough money. And once she was awarded that, it's her position now that she can spend that money however she wants.
Doesn't have to use it for 55 new staff. She can use it for special attorney general.
Yes.
Not attorney general,
Special
DA.
counsel.
Okay,
Right. Yes. Essentially, that is their argument in their reply briefs that they filed in court, that they have inherent authority. They don't have to comply with the county ordinances, don't have to comply with the statute.
So they don't have to comply with our state statute.
That they have, once they're awarded the budget, they can use that budget however. I mean, how their motion, and I'm happy to send the motion, it's public record, but how their motion argued it was, if they get $5 million, they can pay that to one person if they want, as long as because the voters authorized her to do that. So the county, their position is the county authorizes a budget, and she can pretty much has inherent authority to do it however.
even though she specifically asked for the money to prosecute backlogged homicide cases in Atlanta.
Yes.
What's your opinion on that? You think the statute or county procedures permit that?
No, I do not. And I cited several different county ordinances. So when I read the statute, when I read 15-1820, and it makes sense, it makes sense intuitively. As lawyers, when we bill, someone is reviewing our bills. I mean, that's just, that's the process. If you're in private practice, your client authorizes your bills. If you're doing public defense, which I've done public defense, I've done appointed work, the governing agency approves my bills and they will cut them. They will regularly cut them if they're too high. And so there's always some type of budgetary authority that's reviewing everything. So I thought it was very strange that in this case there isn't one, and that there's really no oversight because it is public money. So I know that it's an elected official, but it's still public money. And I don't live in Fulton County, so it would probably aggravate me more if I did.
So we have the code section up that you're referencing for prosecuting attorneys getting additional personnel. That's what Mr. Wade would qualify as, correct?
Yes. So under B, that's the section that authorizes the appointment of special counsel. And it says the manner and amount of compensation to be paid is fixed by either local act or by the district attorney with the approval of the county. And so that's where that's our argument that this was not appropriate expenditure because it did not have county approval.
So our state law requires if a DA is going to go seek outside counsel, I'm going to call them, that must be approved by the county commission.
Yes, without a doubt.
And there are only 3 circuits that have even utilized this procedure.
Yes.
Do you have any idea what rates of pay were approved in those other judicial districts, or, whether they went through some type of approval?
So one was $40 and one was $45, and the annual amount that they spent did not exceed $2,000.
And what did Mr. Wade receive?
He's received about $700,000 so far.
And what's he paid per hour?
$250 an hour.
Has Fulton County been given any opportunity to approve or reject those bills, or the fact that he's even hired?
No. So, and that's an interesting point. So one of the things that the district attorney argued in their motions was that they don't have to have the actual bills approved. So she is the one that approves the bills. So essentially what happens was he would submit an invoice and she would sign off on it and send it to purchasing, and then purchasing would pay for it. So their argument in their motion was that the oversight is by purchasing saying a pay, that she would be the one that reviewed the time. So Ms. Willis reviews the time and then it gets submitted to purchasing, and purchasing then pays it. And so that's the oversight in her opinion. In the state's opinion, the oversight is from purchasing, but purchasing just gets a bill and pays it. They don't actually look at it and see if the work's done.
Does Ms. Willis do that? Is she required to approve these bills submitted by the special counsel?
So the contracts indicate that the bills are submitted to her. She doesn't sign off on all of them. A lot of them were signed off on by other people in her office, purchasing people and things like that. So there's no evidence that I was able to find that she actually scrutinized these bills or reviewed them or anything like that, but she may have.
Okay. And you mentioned that attorneys that are working for state agencies or whatever, including the special assistant attorney generals, submit bills on like itemized statement on what services they've rendered?
Yes, and the attorney general has very specific guidelines on that. What you can bill for, how you have to bill, and is told to remind. There's a reminder that this is public service. So essentially be judicious in your billing.
Right. You go voluntarily get underpaid to be able to help the public.
And a lot of people view it as public service, I think.
Are those bills submitted in like tenths of, I do some billing, in my job, and it's usually 1/10 of an hour.
Yes.
Are there rules or guidelines or sort of standards of practice and how you bill?
Yes. So most law firms, I know because my husband used to work at a law firm, is 6-minute increments. And that's how most lawyers bill in the private sector. Public, it appears that most of them are in 10-minute increments. I know that that's what all of the indigent defense groups, they all are 10-minute increments, but I've never seen anything above that.
Okay. And on the open records request you made to the other judicial circuits, how did those outside counsel bill?
I honestly, I would have to go back and look. They were very small bills, though. They were making less than $2,000 a year, so they were small bills, and they were project based, which I think is also different. They would be hired to do a certain project.
If Miss Willis had hired a employee, one of these 55 employees, and tasked them with the job of going through a special grand jury process and helping seek indictments, investigate these allegations, what's the most they could have made?
Well, first, she couldn't have hired Mr. Wade because it violates county policy. So she would not have been able to hire Mr. Wade as an employee.
How does that violate county policy?
They have a lot of policies on nepotism, relationships, personal. There's a lot of guidelines in the county policies. So she would not have been able to hire him. It would not have been approved. And that would be something that actually did have to get approved by the county. And because of their relationship, that wouldn't happen.
So she wouldn't have been allowed to hire him because of violations of other county policies?
Yes.
He couldn't have been a direct employee of the district attorney's office?
Exactly. He could
This
not.
process circumvented those rules and ethical obligations?
Yes, it did.
Let's say it wasn't Mr. Wade.
So if it wasn't Mr. Wade and someone else, I believe most of the other prosecutors on this case make around $175,000 annually.
I interrupted you. I'm sorry.
That's okay. No, that was the answer. So, if she had hired Mr. Wade or somebody else as a salaried employee, they would make around $175,000, most likely.
So using this technique that didn't obtain approval and didn't have to follow the ethical guidelines of her own office, she was able to pay him $700,000 over 2 or 3 years.
Yes.
I just want to make sure you guys are catching this. This is extremely important. Despite what Fani said in front of the church, she hired Nathan Wade basically as a subcontractor via the agreement to be the special prosecutor, which she was not allowed to do. She could not have hired him as an employee. And if she would have done what she was allowed to under law, she could have hired an employee for $175,000 a year versus paying her lover paramour $700,000 to date.
And
way more than he would have made as an employee.
Way more. And also he's able to have a private practice, which is significant because you're not able to have a private practice if you're an employee. So that's a big issue.
Have you reviewed his billings?
Yes, I have.
Senator Dolezal, will you give us an example of one? I think we have one we're just going to pull up randomly kind of. Okay. Is that an example of the type of invoices he would submit?
Yes, it is. And so
that's an actual one, isn't it?
That is an actual one. And so there's a couple things on this. You asked earlier about the authorization, that stamp that says okay to pay. I believe that's Dexter Bond's signature. So that was one where, Ms. Willis didn't approve it or didn't review it, at least as far as we know from the signatures.
But her chief legal officer did. Right.
So they would do that stamp, okay to pay, sign it, and then send it to purchasing. But yes, this is one of the bills. And so he had monthly caps, which went up. There were a couple different contracts that were renewed. So he had one contract that expired, another contract, and the monthly cap was $35,000 a month. So that's where you see the total. But this billing is not something that you would normally see.
All right. Well, I'm noticing it lists the day and just a number of hours. There's no real itemization of exactly how much time you spend doing whatever type of task.
Right. There's none at all. And I also open records because in Fulton County you have a badge to access everywhere. So I didn't open records for his badge access. I was told he didn't have a badge. I was told by other witnesses that he did. So, I don't know, but that you would, if you were doing these things in the office, you would. I used to be a Fulton County employee. You have to scan, and they keep track of all of that. So you have to scan your badge to get in to certain places. So if he's doing this, even as a contractors at the jail have badges. The medical providers have badges. They all have the badges that they scan. I open records to the sheriff and the DA's office, and both of them told me that he did not have an access card. But in order to do this, I would assume he would have to have one to get into the DA's office. And I have been told that he had one, and those you'd be able to see when he went in and out. Okay. But I was denied that.
Anything unusual or irregular about, this is just an example, Bill, about the way he billed the county?
completely. I mean, this is, you would never see this. This is what I would call block billing. So it's, I mean, one of them, for example, it's 28 hours over the course of 2 or 3 days, team investigation meeting and drafting. I went back and looked to try and see, a lot of these were like drafting. And at the time, I'm not sure what would have been drafted because most of this was during the special purpose grand jury. So there's not really a whole lot of drafting. We've obviously never seen anything that he specifically has drafted, but I also calculated these team investigation meetings. So the majority of the billing are things like meeting with team. So if you see here, it's got team investigation meeting, then it's got team meeting and argument prep, and then meeting with team. Most of his billing is meeting with team meeting, team investigation, team brain drain. He called it different things like that. But I went through and I mean, that's the majority of the bill.
And this wouldn't be standard from what you see at block bill in 8-hour increments instead of, you said, 6-minute increments or
No,
more specifically, and does not really give a lot of identification of what's being done.
it gives pretty much zero, in my opinion, identification. I mean, this is not something that we would be able to submit to a client ever. I can't imagine. I mean, they would, if I billed them $2,000 for 8 hours of meeting with a team on one day, and just research without what I'm researching. I mean, you have to be detailed in your bills because that's accountability. I mean, that's the only way as lawyers we can be accountable. Our clients aren't sitting in our office while we're researching. So I have to say what I'm doing.
And somebody has to approve it.
Oh, yeah.
And it's ultimately Fani Willis that was approving these either personally or through her designated assistant.
All right. So once again, what we have here is we have yet more evidence of the corruption between Nathan Wade, Fani Willis. There are many other stories unrelated to the Fani Willis Fani Willis case. I'll be taking a super deep dive in where Nathan Wade is doing exactly the same thing. He's screwing the taxpayers, or at least screwing wherever the money's coming from, by having this block billing or these generic terms that no one could ever go back and figure out what he did. If I hired an attorney and they sent me a bill like this to pay, and I've had some huge attorney bills in my life as a professional, they are always very detailed with exactly what they did on my behalf and when, and I would never accept a bill like this.
Yes.
And there was a written contract with Mr. Wade and the Fulton County DA's office.
There was, yes.
All right, let's see if we can pull that up, Senator Dolezal. Am I right that I think I've reviewed your documents, that there were more than one contract?
Yes, there were.
Is this the first one?
Yes, that's the first one.
All right, so that says it shall commence November 1st of 2021 and go through October 31st of 22.
Yes.
Okay, so that contract began before there was even authorization to have a special grand jury, and later in November of 21?
Yes, it did.
Okay. Does it specify that that's what his role was going to be, or is there any way that's disclosed to the public what he was doing?
No, up at the top, I believe it says, let's see. It just says attorney consultant. This one, so if you look under whereas, the first whereas, it says to provide legal services regarding anti-corruption matters. The head of the anti-corruption unit is a lady named Sonia Allen. And she was the one that was originally in the emails that I talked about earlier, negotiating immunity and things like that. So she's the head of that unit.
So the DA's office has their own special anti-corruption unit already in-house?
They do, and they have a director of that. Sonia Allen is the director or chief assistant. She heads that unit. And she was the one that was originally on the emails negotiating immunity and things like that. And then it switched over to, there was some issue, I believe it was with Governor Kemp, on him testifying when, all of that stuff. And Mr. Wade took over and said, I'm the only one with authority. And so Ms. Allen sort of stopped working on the case, and she hasn't really worked on the case since.
From your experience and your knowledge of Mr. Wade and Sonia Allen, does he have any special unique experience or expertise that would make him better at this anti-corruption work than the head of the anti-corruption department in the Fulton DA's office?
No, but I mean, no, he would not. But Sonia Allen also hired Mr. Wade in Cobb County before this contract at, I think it's like $550 an hour or something, to investigate deaths in the Cobb County jail. So Sonia Allen was the chief. So when Neil Warren was the sheriff in Cobb County, Sonia Allen was the chief deputy. And so she basically ran the sheriff's office. They had a couple different deaths, and there were some lawsuits over access to that. A lot of the local lawyers wanted access to what was going on with the jail deaths. And Miss Allen hired Nathan Wade to do that work, to do an investigation. And so a lot of this came out because they were ultimately sued. So I reviewed part of what I did in this case was I reviewed all of those documents as well. Mr. Wade had to testify because one of the news organizations sued them and said that essentially Miss Allen hired Mr. Wade to try to get around open records, to say that it was an open investigation so that they didn't have to give the jail recordings to the families about how these inmates died. Mr. Wade was a witness and had to testify, and he had billed a lot of money.
That inmate death case is the case I keep referring to, involving additional malfeasance on the part of Nathan Wade and Fani Willis, allegedly. More to come on that.
Which I don't have a figure, but I've got the invoices. But he had billed quite a bit of money to Cobb County, but hadn't produced any documents. And so he had to testify, and his testimony was that everything was in his brain, that he didn't have any written documents from anything. Right. But that's where
That was some years before.
That's what I was talking about. He said, I have nothing to produce. All of the work product is in my brain. Looked extremely shady then, and repeat going on now.
That was some years. I think it was in 2020, maybe.
So
it was right before
when
this.
did Miss Allen get hired by the Fulton DA's office?
When Miss Willis took office. So when Miss Willis took office was the same time that Mr. Warren, who was Miss Allen's boss, was no longer the sheriff in Cobb County. So a new sheriff was elected, Craig Owens, and so he was elected in Cobb County. He took over that office. Miss Allen no longer had a job, and she was hired by Miss Willis to head the anti-corruption unit.
Okay. So from your documents you produced and your news stories that I've read it, apparently there were other special counsel that were hired by Miss Willis?
Yes.
And to work on these specific RICO cases or election fraud cases?
Yes. So there's several. And so that's kind of a longer answer because there's a couple different classifications. Mr. Wade was, at the time that he got this contract, he was law partners with a gentleman named Terrence Bradley and another gentleman named Chris Campbell. So it was a three lawyer firm. Both Mr. Wade and Mr. Campbell had contracts also. They actually had contracts before Mr. Wade. So they both got contracts the month that Miss Willis took office. They got contracts to do what's called taint work, which is essentially if, for anti-corruption, because it's a lot of police brutality cases, if there's things that could be considered privilege. So let's say the police union had a lawyer doing an investigation, they subpoenaed those records, those are privileged. Somebody has to review those to see what the DA's office can actually see. So it's that wall, that privilege wall sort of. So both of Mr. Wade's law partners had contracts to do that privilege review, that taint review, conflict review.
So you're seeing if there's tainted evidence, something that should not be revealed.
Basically what they're talking about is that obviously Wade was using his position with Fani Willis, and she was apparently giving him a bunch of favorable contracts. Wade obviously has a long history of this shoddy, mysterious work that he cannot prove that he did by the way he's billing and or in reality, because he can't produce no papers. And then there's something called taint work. And essentially what it is, it's special work that pays you a lot of money for very little work. And you basically look at documentations and decide what can be given over and what cannot be given over, because there may be some type of privilege exerted over the particular type of work. So that's all that is when you hear the taint work. And finally, at the time, November 1st, 2021, when the contract with Fulton County DA's office was inked for this so-called RICO case for Wade to be the special prosecutor, at the time, he was still partners with our best friend, Terrence Bradley, and another gentleman we haven't talked a lot about by the name of Campbell, that I think he actually might be partners with now, or at least has a loose affiliation with him.
Might damage another case, or it might be privileged and not subject to disclosure. Right,
exactly. And one of the best examples I could give is, in the Tex MacGyver case, he was a lawyer they seized a lot of his documents. A lot of them were attorney-client privilege related to other people. The DA's office was not able to just go through all of those. So they had to have a taint team, is what they call it. And so that taint team, and I don't know which cases, but the taint team involved Mr. Bradley and Mr. Campbell, who are Mr. Wade's law partners.
Basically, they're reviewing documents to see whether they should be produced or privileged by attorney-client privilege or something else.
Exactly.
Not exactly prosecuting criminal cases then.
No, they weren't prosecuting criminal cases. But Mr. Wade testified that they were law partners at the time, so that he would have shared a third of whatever contracts they got. So those contracts he was getting paid essentially from the law firm as well.
All right. So on this case, these RICO cases that you're involved in, one of them, there are other special counsel in addition to Mr. Wade?
Yes. So there's two other on this case particularly. There's a lady named Anna Cross and a gentleman named John Floyd. And John Floyd has worked with the DA's office for many years. I actually was involved in another RICO case year before this one, which luckily my client resolved his case, so I'm no longer involved in. But that case, John Floyd had also helped craft the indictment. And, he's sort of known as a go-to person for racketeering cases. So the district attorney would regularly call on him to help in drafting indictment. Anytime we would file what's called a demur, which is a motion to quash an indictment, he would usually be the one that came and argued it. And then Anna Cross was also hired, and she really focused on the work in federal court. And both of those sort of make sense to me because Fulton County prosecutors they're not necessarily barred in federal court. It's not something that would be required for your job. When I was a public defender in Fulton County, I wasn't barred in federal court. I had no need to. I wouldn't have paid the dues, wouldn't have done that. So it's not something that would be required for their job, but Ms. Cross is experienced in that. So she was hired sort of as a subject matter expert to litigate some of the federal removal issues in this case.
Did those two individuals have contracts with the DA's office as well?
They have had contracts historically.
This is part of some of the oddity of this case, to put it bluntly, was the fact, why would DA Willis not give the RICO head, the head of prosecuting this case, to someone like John Floyd? He's the one that's the quote unquote expert, allegedly, along with Fani Willis, as far as RICO prosecutions are concerned. And she also mentions Anna Cross, who deals a lot on the federal level with federal type cases. But both of these individuals have a lot more experience compared to Nathan Wade, who essentially has no experience, has never prosecuted one felonious case in his entire life, and sure did not prosecute any type of RICO case, nor did he have any idea what he was doing.
Historically, they do not currently have contracts. Yeah. It's very odd.
Did you review their billings?
I did. I reviewed their billings. Stark contrast. So Mr. Floyd, for example, he was only paid at a rate of $150 an hour. And
Same case.
And he
more experience and expertise in RICO cases.
I mean, everybody would agree. I think that John Floyd is one of the preeminent experts on RICO. Yeah. I believe he testified in front of the Georgia legislature when RICO was passed.
Did he have to submit itemized invoices?
He did, and his were very different. His were significantly reduced, and the big difference was he billed for the time that he was working on the case, not necessarily like 8 hours for team meetings.
Do you have itemized billings?
Very much so,
and
yes.
What increments did he bill in?
I might have some of his contracts with me, but it was either 10 or 15 minute increments. And so did Anna Cross. Now, Anna Cross was paid $250 an hour. Anna Cross is very well-known, very experienced appellate, federal lawyer, does a lot of complex litigation. She was a DA for many years, handled a lot of high-profile cases for the district attorney's office. I mean, I know her back from when, we did death penalty work in Cobb County together 15 years ago. And then she went to DeKalb County and prosecuted a number of high-profile cases there, but just very well-known. And her bills were also submitted, but they were the same rate. They were $250 an hour, but they were much lower bills, not anywhere near the bills that Mr. Wade did.
Do you know how much Anna Cross has received during the course of this criminal prosecutions or
I'm not sure.
Investigations?
I might. Let's see.
Okay. You said Mr. Wade had about 700,000 so far?
Yeah. Oh, Miss Cross was under 100,000, I believe.
All right. So if she's under 100,000, what about Mr. Floyd?
Mr. Floyd, much lower, even lower than Anna Cross. he has not billed in a while. So I was subpoenaed, or not subpoenaed. I did subpoena, but I also did open records for all of his bills. We've not been provided anything recently from him. So I'm not sure if he actually did bill, because his contract said you have to submit the bill within a certain amount of time. So I'm not really sure. They stopped responding to my open records requests. But when they did respond, they were very, very limited, very small bills.
Yeah. And your open records request was to whom? The Fulton County government, commission, or the DA's office?
I did them to all of them. And once, especially that they stopped responding to them. So they have a portal, and if you go to the DA's office and you click open records, it takes you to the Fulton County portal. So if you try to submit it to the DA's office, it necessarily goes to a portal for the entire county. So you have to submit it through those. So that's where I would submit it. You can designate, I think this is the DA, I think this is budget, things like that. So I would be over-inclusive just to make sure that I wasn't missing somebody. But every single time they would route it to the DA's office. So I would get a response that said it's been routed to the DA's office, and we're waiting on the response. There were one or two that I got from the county that didn't appear to be routed to the DA's office.
Right. And so who's refusing to produce these records to you?
The letter came from Dexter Bonds at the DA's office.
And
Dexter
that's
Bond.
why you filed a lawsuit against the DA's office to force them to comply with open records?
Yes.
Okay, that's still pending?
It is still pending.
Fulton County Superior Court?
It's Fulton County Superior Court. It's assigned to Judge Krause, I believe. And the county attorney contacted us and says they're going to be responding. So the county attorney is actually defending that lawsuit.
Right. And so they're telling you they're going to respond to the case or respond to the request now? You're waiting to see.
I believe the case. I haven't received any documents, so.
Fairly recent filing you filed there, or that lawsuit?
Yeah, so we filed it in January, and then they had a little shutdown in Fulton County where nothing was able to be file stamped. Our process server couldn't serve it until it was file stamped, and the Odyssey, the e-file system in Fulton County was hacked, and so.
Yeah, remember we talked about in recent videos that it's not really published worldwide, but it's been very clear that the Fulton County DA's office has been hacked by some type of hacking organization. You know how you hear on the news every once in a while that this hospital was hacked and they're demanding a ransom to be paid? Well, the same thing is currently going on with the Fulton County District Attorney's Office, which is kind of interesting, and they are threatening to release records that are, they call them interesting, pertaining to Donald Trump and this case if their demands are not met. In addition, what Ashley Merchant is saying is among all the stuff going on, I had to file a lawsuit. This particular lawsuit pertains to open records, which they are supposed to give under state law freely upon demand. And of course, in this case, as alleged by Ashley Merchant, they are failing to do that. Therefore, there's yet another lawsuit pending.
Was shut down for a while, so it took us a little bit of time to get a file stamp copy back, but it's now been served. But it was filed on January 30th.
Of 2024.
2024. And I have a copy, which
I don't have that. If you would provide us with
Happy
that,
to.
then we'll give it to the Secretary of the Senate as a supplemental response to the subpoena.
I'm happy to. This is a clean copy.
Okay.
Yes, so you all can.
So what's the relevance
this.
to you? Why did you seek these billing records of these attorneys?
I wanted to compare the different billing, the different styles of billing. Also, there had been an allegation that I was singling out Mr. Wade. And so I thought it was relevant to see the rates that the other attorneys were paid, their billing, what type of billing, if they billed for everything. Just for example, when we're in court, one of the prosecutors may be arguing, Mr. Floyd and Ms. Cross aren't there billing. But Mr. Wade is always there. So that was one thing that I noticed. And I understand now that their response is that he sort of is like a case manager almost. So I guess that would be why he's always there. But I just wanted to compare them and see. Okay.
I think I want to show a couple of things. Senator Dolezal, I want to show some of the other billing records, particularly ones that showed the trips to DC. We hadn't had but a couple of days to review all your documents, and I skimmed these records because I wanted to know exactly what was going on. You'll see highlighted down here at the bottom on November 18th of 22, interview with DC White House. 8 hours. Do you know what that references?
Based on another motion that was filed in our case and the arguments that were made by the DA's office, I believe that was when they met with the Department of Justice. They met with the January 6th committee.
This is getting into the evidence that we have been talking extensively about, which is more proof that the Joe Biden administration has been collaborating with all of these different felony jurisdictions pertaining to going after and hammering Donald Trump. And this particular bill proves that the DA Fani Willis office has been and was collaborating and basically trying to orchestrate this particular hammering of Donald Trump. Everybody's working in tandem together. They're going after Donald Trump. It's clear, and these records are just more proof.
So one of the co-defendants filed a motion to try and get some documents, and the state had to respond. It was a motion to compel. I was there for it. I joined it, but I didn't litigate it. And the state said that they had to meet off campus. So because they didn't have a record of it, I guess you have to have a record if you go into the White House. And so they met with the January 6th committee off campus, and they said they had a really hard time getting that meeting. And they had to have someone who had some source or something to get them to agree to the meeting. But that's what, so the motion to compel was based on this entry.
Yeah.
And this entry, in response, they said they were meeting with the DOJ and someone with January 6th.
Okay. There's also an entry, May 23rd, 22, travel to Athens conference with, what is that, White House?
Yes. And, we've tried to figure out what and who that was, because there was something happening at UGA Law School. And so we just assumed that it was someone that was there and that's why they met there. But I don't know.
Do you have reason to suspect, or can you confirm whether or not Ms. Willis or Mr. Wade were coordinating with the Biden White House in the course of this investigation and prosecution?
The discovery, they've got a lot of our discovery involves the January 6th. A lot of what we have in discovery is the same stuff that other places have. So they had to have gotten it from somewhere. And they also, they read a lot of the testimony. They played testimony in the special purpose grand jury. So, I don't know how they got all of that, but they got it somehow.
We know how they got it.
And then, there's one of the other things I did was I did a open records for the White House access, and we had records that Ms. Willis and the mayor of Atlanta were at.
Janet, the answer to your question is pretty simple. This is something that is really at the heart of everything we're talking about. The reason these individuals are meeting with the January 6th Commission, the Biden administration, their attorneys, whomever, it just shows the grand conspiracy going on to get Trump. It's just that simple. It's election interference. You put whatever label you want on it. The real RICO situation is not what allegedly President Trump did down in Georgia. The real problem is the devil went down to Georgia, which is Fani Willis, DA, and they're all doing at the behest, urging, and at the planning of the Joe Biden White House. Everything from New York to South Florida to Atlanta, Georgia is being coordinated. Anybody doesn't believe that, you need to really examine the facts, because that's exactly what's going on. So thank you for that question, Janet.
Meeting with the vice president.
Okay, and so this is the access history. How does that work? The White House keeps records of anybody that comes in and has any kind of official meeting, for sure.
Yes, and my understanding is it's highly regulated who can access the White House, and so you have to apply.
You'll see that right there. From what she's saying is this is proof that there was a meeting with the vice president of the United States by Willis. See, it says Fani Willis at the top. It also says Fani Willis. It's got the date. It's got a stamp time of the beginning and the end. And the visitee is, of course, V. POTUS, Vice President of the United States. Has got the location, South Lawn, in some kind of tent, 5/30/2023. Boom.
in person or apply ahead of time. And then they give you a time when you make the appointment, and they give you a time when you're allowed to be in and when you have to be out by, and they track you. And I mean, that makes sense. They don't want anybody, lingering in the White House. But they keep that. And so they're called WAVE records, I believe is what they're called. And I'm not sure what that's an acronym for, but they're publicly available. They're open records.
And this record that's shown on the screen shows Fani Willis was a visitor with V. POTUS. I presume that's Vice President of the United States.
Yes, it was.
And what was the date of that back in, was that February sometime of 23?
February 28, 2023.
Is that before the indictment?
Yes.
Okay. Any further explanation of why Ms. Willis was meeting with the Vice President of the United States?
No. I know Dexter Bonds, and I believe that's the same one that I think it's Dickinson or Dixon, the mayor of Atlanta, was also there.
Okay. We're going to take a short break. We've been going at this for a while. Let's take a somewhere between 5 and 10 minute recess, and we'll be back. Thank you. We're in recess.
All right, this is getting pretty interesting. So this right here just proves that there's definitely consultation, collaboration going on between the White House and all these cases, especially the Fani Willis case in the state of Georgia. It is just corruption, folks. When you get right down to it, doesn't it just anger you with every fiber in your body that they can get away with this type of stuff? I hope they don't get away with this. And Janet, you were asking about the January 6th committee. We can only speculate as to why they're doing what they're doing, but I think very clearly it's obvious that they're all working together in order to bring down Donald Trump. Folks, I think the easiest way to say it is there is these individuals all working together, and their sole goal is to find a way to take Donald Trump down, prevent him from running to be the next president of the United States in the first place. And obviously that doesn't seem to be working. So the next plan is to try to hurry. So if you want to know why they're doing it now versus 4 years ago, because they weren't sure he was going to actually run again to be president of the United States. So they're going after him now because they want to get some type of felony conviction on this man to stop him from running to be president. Now, the conviction itself will not stop him. There's nothing in the Constitution that says you have a felony, you can't run to be president of the United States. However, they're hoping, they're hoping, folks. They're just throwing everything against the wall they can and hoping something sticks. Their thinking is some of these polls allegedly say that if former President Donald Trump was actually convicted of a felony, certain individuals would not vote for him and they would vote for Joe Biden instead. And I have a hard time believing that. I have to believe most Americans see the truth for what's going on. For example, you take the New York case of Alvin Bragg. I cannot imagine someone saying, oh yeah, I support Donald Trump. He's the man for me. I like this, this, and this. Oh, hang on a second. They got a felony conviction because he mislabeled the check that his business wrote the porn star in order to keep her quiet back in 2015, 14, 15, 16, whenever it was. Oh, therefore, I'm going to go ahead and vote for Joe Biden, which is a de facto vote for the future president, Kamala Harris. I don't believe that. Do you guys believe that? I don't think people believe that. Everybody knows what's going on. And if they don't know what's going on, they need to be watching this channel because they need to have their minds set free, as I like to say. So let's move through this stage and let's get right back into the next part of this. We're going to go ahead and fast forward it while we chat here. I like these controls they have on here. Tell me in the comments if you guys agree with what I'm saying or not saying. I find it just absolutely... I just can't get my mind around whether or not these people think this is going to be successful. And if they end up getting a felony conviction on this man, that people would stop supporting him as a result of that. I don't see that happening at all. I can't. Most people I talk to tell me what I just told you. It's not going to affect their vote. So it always makes you wonder exactly what's going on with these people as far as their thinking and stuff goes, because it wouldn't affect my vote. Let me know in the comments if it would change your mind. Everybody knows this is a politically motivated case of one sort or another. So, all right, looks like it's about to start back up here. I don't want to miss anything. So we're going to go ahead and let's just start sliding forward. I appreciate everybody's comments.
1 minute.
Yeah, they got a 1 minute
committee
thing.
Members on their way.
We're going to fast forward it and just get it going quickly. So, we're going to be right back into it. Of course, they're taking a short recess, and we're going to dive right back into it. I promised you this was going to be intriguing, and I was not kidding around. She fills in the blanks. I've had a lot of questions, a lot of how did this happen? Wait till she starts talking about Bradley, the ex-law partner of Nathan Wade, and exactly how she got all that information, and how a month before he testifies,
we were reviewing the billing practices.
he's like, "Oh, I just love her to death. I'm glad that you're going after my ex-law partner." She's going to get into it right now, so we're going to join it right now. Here we go.
Various outside counsel had, and I pulled up here one section of Mr. Wade's bill for the really early on in his involvement in the case. As I recall, it began on November 1st of 21, so this would be out of his first bill. I see on November 5th, prepare case for pretrial, 24 hours on one day.
Wow.
What do you make of that?
I mean, I thought it was astonishing that, you didn't sleep for 24 hours. I've been to trial. I'm sorry. I've been to trial and had to work long hours, but 24 straight. But we did question him about that at the hearing, and he said that that's when it was concluded. So how he explained it was November 5th is when the work was concluded. And so he had done that work up until then, and that he only billed when it was concluded. So he said that the 24 hours, who knows when it spanned, but that how he billed was
would have had to be between November 3rd and November 5th, though, right? So it had to be on the 4th and the 5th, 12 hours a day?
It had to
at
be.
Least.
And, the other thing that I noticed with this is prepared cases for pretrial. At this point, it says anti-corruption unit. His two law partners are the conflict lawyers for the anti-corruption unit. So you've got it's like my husband couldn't represent someone who's adverse to me. Like my husband is my law partner. He can't be doing privilege review on a case I'm prosecuting. So he's consulting on anti-corruption cases for the DA's office, where his two law partners are doing the privilege review at the same time. That's one, that plus the 24 hours are the two things that really struck out to me.
So, but the only role he had was this prosecution of this election fraud.
Yes.
Okay.
Yes. The only role.
Okay. So when it says anti-corruption, that's the corruption. We're looking at election interference.
Yes. He's never worked on any other case.
The corruption is the bill itself.
Let's see that other bill there, Senator Dolezal. All right. So here's another one. If you can see that, okay. This is the one we put up earlier. It looks to be much more specific date-wise anyway than just those 24-hour chunks like that. Okay.
Right. I mean, it's more specific, but it doesn't say what, like just for example, team meeting and argument prep for what?
Folks, when you see an attorney bill and it says stuff like, "Oh, I met with my research team for 8 hours at $250, $2,000. I had a meeting with my team drafting or whatever, and it's so many hours straight." This is the reason why attorneys generally, ethically, will itemize out anything and everything they did and say what they did, because this is ripe for fraud. And any common person on the street would look at these facts and say, "Oh, he's ripping off the taxpayers." And of course, that's exactly what's going on. And he was doing it at the behest and urging and with the blessing of his lover, Fani Willis.
I mean, normally when we do bills, we would say, argue motion to dismiss or argue whatever the motion is. Research. What are you researching? Researching statutory privilege, whatever it is.
Yeah. Now this one, he shows date ranges when it's over multiple days, like down at the bottom, 426 to 427, 18 hours.
Right.
If I'm reading that right, or 16 hours. But on that previous one, he just has one date, 24 hours.
Yes.
Okay. And you say these are approved by Fani Willis. By contract, she has to approve these billings.
Yes, she does. And those are approved by her. So if there were any questions, and as a lawyer, when we submit bills to clients, they regularly question, and I know when I've done appointed work, they regularly question that as well. You have to list exactly what you're in court for, exactly what you're drafting. You can't just say prepared cases. You've got to say, what did you prepare? What did you draft? So, the county in Cobb County, for example, they make you actually attach motions. If you do like an appeal or something and you're billing for that, you have to actually attach it to prove that you did the work. I did go back at the break though, and I have an answer to one of your questions earlier. I just wanted to clear up. You had asked me when the special purpose grand jury had convened. I looked, the state filed a response. So this is DA Willis's response that was filed on February 2nd. They wrote on
This response to your motion to disqualify?
Yes, sir. Okay. Response to my motion. On page 13, they wrote, shortly after his appointment in January 2022, District Attorney Willis petitioned the Chief Judge of the Superior Court to convene the Superior Court judges to consider her request for the special purpose grand jury, to conduct an investigation into the facts and circumstances relating directly or indirectly to the possible attempts to disrupt the lawful administration of the 2020 elections of the state of Georgia. And they attached that exhibit. So you had asked me earlier when she petitioned. So it was, in their own words, shortly after his appointment.
Okay. So this whole, the cases are about attempts to disrupt, because obviously Georgia certified Biden as the winner and he got inaugurated, that following January. And this is years later, we're having this whole investigation.
Yes, attempts. And my client specifically is charged with attempt and conspiracy. So he's not charged with actually doing a specific act. He's charged with conspiring and or attempt, depending on which section you're talking about in the charges.
Some of these itemized statements show drafting.
Yes.
Did Mr. Wade draft any documents to your knowledge, or prepare any legal documents at all?
No, not that I'm aware of. And that would be.
Did he sign any pleadings as if he was the drafting attorney?
No, and he's not the one that usually files them. Will Wooten is the one that usually does the filing. There's two other prosecutors that also do it. Alex, and I don't want to butcher his last name, starts with a B, but he does it. And then Grant Rude. Anna Cross has also filed pleadings, but not Mr. Wade.
In your review of all of his billings, did you ever see where any of his time or bills were cut or reduced by whoever was reviewing them and approving them, either Ms. Willis or her deputy?
No, I never saw any questions. And her response, or their office's response, doesn't indicate that was ever done either. And
your experience when you were doing like your public defender work, that you were reviewed and they cut your time?
Oh my gosh, yes. Yeah, when I first left the public defender, I had a couple clients that were in the appeal process, because I was in the appeals division when I left, and I didn't want their cases to linger, and I didn't want a new lawyer to have to kind of just pick up right when they were going to the appellate courts. So I kept some of them. Some of them the judges appointed me, and so I would be paid, I think it was $50 an hour, $45 an hour, something like that. And then some I just took pro bono, but I had to get those bills approved. I mean, they were regularly cut.
On Mr. Wade's contract, he was allowed to bill, he was capped. He could not bill more than $35,000 in any given month.
Yes. Yeah. And that was not, so the original contract before the special purpose grand jury was started was a lower cap. This was the cap for the majority of his work during the special purpose grand jury and then now. So he had a contract November 1st, 2021 up until October 31st, 2021. And the cap was lower for that. Then there was a period of, I think it's 15 or 16 days where he did not have a contract. Which also happened to be one of the times they were out of town. But so they re-upped the contract November 15th, and then it had a cap, but the cap was significantly higher. I mean, I don't remember the first cap, but it was not 35,000.
Here is a document you produced. I think you prepared this summary that shows all the payments that he received.
Either I did this or this might have come from Fulton County purchasing.
All right. Okay. So that was produced to you from Fulton County as
yes.
all the payments he received?
Yes. This was produced from Fulton County, yes.
And what's the total? Is that just, my eyes aren't so good. What that looks like 22 all the way through 23.
Yes, 22 through 23. So so his first bill would have been paid in January of 2022. So he billed for time in November, December, and then you see those two bills. And so those were $15,000. I believe that was the cap. So in right. January he was paid for $15,000 for work in November, and then in December he had work totaling $15,000, and he was paid for both of those in January.
That's why there's those top two invoices for $15,000.
Yes, that's why there's those top two invoices. And they produced some other documents to me as well that showed which funds they came out of. So I was able to track which ones came from state seizure money and then which ones came from county general fund.
And that was all before this grand jury was even approved.
The grand jury was not approved until June of 2022.
Okay, it was requested in January.
It was, and I just looked that up at the break. So it was requested in January. It was approved in June, the order actually. But what happened was they started picking. So it looks like they started picking the grand jurors on May 2nd of 2022. And they actually started hearing evidence June 1st of 2022.
Okay, so lots of this time was way before he would have been having to question any witnesses or attend grand jury hearings or anything.
Yes, he could not have attended a grand jury hearing until at the earliest May 2nd.
You were talking about the experience and expertise of the three outside, I'm gonna call them outside counsel, because they were not direct employees of the DA's office.
Correct.
Had Mr. Wade ever tried a felony case, prosecuted a felony case before this, to your knowledge?
No, that he has never prosecuted a felony case. And I asked his law partner that, who had been his law partner for some time, that he had never prosecuted that. I also did some independent research in the metro areas where I knew that he had worked in Cobb County. So I looked to see if he had ever been filed as a prosecutor in Cobb County for felonies. And he was actually just a solicitor, and solicitors is, because you said not everybody may understand the difference between solicitors and district attorneys.
We've got an ex-solicitor on this panel, so don't say anything negative about him.
So he can tell you all about it.
They prosecute misdemeanors only, right?
Yes, and in Cobb County specifically, they prosecute misdemeanors, yes.
Okay.
Yeah, so in the state of Georgia, if you ever hear him talk about, well, he was a solicitor, like he's a big deal, remember, in the state of Georgia, the solicitors or the DAs, one of them only prosecutes misdemeanors, not felonies. So that's the distinction right there. And according to Merchant, as I've been saying, Wade never prosecuted one felonious case.
It looks like he's pretty much hitting the maximum that he was allowed to under his contract.
Yes, most months he did.
Okay. And this is through that block billing that was not specifically itemized exactly what he was doing or how much time on each task.
Always block billed.
Okay.
He never itemized bills, never was specific.
What were the caps for the other two special counsel? Were they also limited? I assume you've received their contracts, or did they have a written contract?
They did. So they had written contracts, and I do have those, and they did have caps. They were significantly lower than Mr. Wade's. They do not currently have contracts. And I just found that out at a hearing because we had asked for that. We had asked for it in open records, and then I had subpoenaed it as well. Pretty much every subpoena I filed for the hearing, the state filed a motion to quash, including this one. And Ms. Cross was at the hearing, and she said, I can just tell you right now, I don't have a contract. So I had thought, I was under the impression that they just weren't giving me that contract. I had no idea that they just didn't have one. So apparently right now, Mr. Floyd and Ms. Cross don't have contracts.
Do you think that was intentional so that they don't have to disclose how much they're earning?
I think it was sloppy.
Okay. Does Mr. Wade have a current contract?
Yes, he does. I also think it may have been, I don't know if it's disclosure, but I can tell you that they've changed since I started looking at this. They've changed what they put on the public documents. I used to be able to go to Open Checkbook and see every time he would get a check. And since I filed this, none of them have come up. So I don't know if he's not being paid anymore or if he hasn't filed any invoices, but the invoices are due, I believe, 30 days after. So, they regularly came up, but now all of a sudden they don't.
Okay.
Yeah, she's saying that essentially there's no contract, at least recently, pertaining to Ms. Cross or John Floyd, which are part of the prosecution team. And probably what's going on with the no contract is there's some kind of malfeasance going on in the sense that they have to treat you one way if you're an employee, and they can treat you another way if you're not an employee of the state. So as she's alluding to, and as this chairperson was asking, there's some kind of nonsense going on, folks. This whole thing just smells.
So eventually you sought to disqualify Ms. Willis from serving as counsel and prosecuting Mr. Roman's case.
I did.
Okay. Can you pull up that motion? That motion was filed here in January. I think it was January 8th of 2024.
Yes.
What was your motion to disqualify based on?
It was based on a number of things, but it was based on mostly the fact that Miss Willis and Mr. Wade had a romantic relationship, and they had been traveling, and he had been paying for a lot of that travel. So there were a couple different things. She had not followed the statute. So the statute I referenced earlier, 15-18-20, said that you had to have county approval. She didn't have that. So that was one thing. There were also—
You had figured that out through your financial records?
Yes, I had figured that out through my financial records, through open records, through reviewing all the Board of County Commissioners. And I actually, to that motion, I attached, just on this issue, I actually attached a document showing how independent special counsel would normally be appointed. I'm sorry, special counsel, because I found one where, and I think it's exhibit, let's see. It's exhibit J. I found one where Fulton County had actually been asked to approve a line item for an independent contractor agreement. And so this, I used it as an example of what normally would happen.
Was that for an attorney?
It was for an attorney.
So she's saying in pleadings now that she's not required to get county approval, but in the past, for people other than Wade, she had gotten approval?
This is actually the county attorney. So
Okay.
This document is the county attorney. I do not believe she's ever gotten approval for anybody. And her filing said doesn't. I mean, her filing, I at the break, I was looking at it. I mean, she said that that I incorrectly contend that the appointment exercised by, and in parentheses, a state constitutional officer must be followed by an approval of the local government's Board of Commissioners. And she says over and over again that I'm just wrong, that she doesn't have to because she's a state constitutional officer. So that was their position, that she doesn't have to.
So is that one of the grounds for your motion to disqualify these, let's just call them financial irregularities, that she had not complied with the state law or county policy of getting prior approval?
Yes, that was one of the primary bases. But then I also reviewed case law and saw, the conflict of interest. And, our motion, the theory, basically just to sum up the motion, is that essentially he's getting paid all of this money and they're not going through the proper procedures. And I go through it in the motion. I talk about how he didn't file an oath, which is rare, I'm one of those.
Didn't follow what?
He didn't file an oath of office. Yeah. And I'm one of those people that I always, when I first start a case, I always make sure that everything is all the I's are dotted and the T's are crossed. So I always pull that. Anytime I've only ever had special counsel twice, and it's been people who were not paid, who were district attorneys in other jurisdictions who took the case on, which is the normal process in the state. But I've always pulled that just to see that they're sworn. That's something that's important to me. And I couldn't find it. So I did open records to the probate court, to the superior court, and there was no oath of office filed.
Sworn for the special assistant district attorney?
Yes. If you're going to be inside of a grand juries are highly regulated. I can't just go in a grand jury. None of us can just go into a grand jury. So you have to be a sworn officer of the state to actually be in there, particularly to present evidence. And so I wanted to see if he had taken an oath. And that's something that, you would file. It should be publicly available, not something that's really, highly contentious or secret. And there wasn't one. So, once I learned that, I was like, why are they not filing an oath? This is odd. There's no public approval of these contracts. There's no oath of office filed. This is different. What's going on? We later found out that he had taken an oath, but nobody had filed it,
Okay.
And the law requires, there's a statute that requires you actually file it.
I have looked at that. So the statute for a district attorney, their oath, when they are sworn in that position, says, I do swear that I will faithfully and impartially and without fear, favor, or affection discharge my duties as district attorney and will only take my lawful compensation.
Yes.
So help me God. Did Miss Willis sign her oath that swore she would not take?
Okay, there's a little bit to talk about here, so I don't want to get too far ahead of this right here. Now, just for discussion's sake, remember Ashley Merchant, she was working with her husband, John Merchant, and John Merchant, the guy with the gray hair, silver hair, whatever you want to say, I thought originally that was her client, Michael Roman, because they look kind of similar, except her husband has lighter hair. I just figured his hair was light from all the stress. At any rate, that is her attorney, and they have 2 daughters. And I agree with whoever made the comment that she's pretty. I've always said she is beautiful and she is highly, highly intelligent. What they're discussing right now is the fact that she is a stickler for details. And this is the kind of attorney you want. And that's the reason why all these people are about to get a nice big gift, because this case is going to be kicked out. And in all likelihood, Fani Willis, Nathan Wade, they're going to lose their law licenses, probably in addition to Terrence Bradley, and who knows what kind of criminal issues they're all going to have as a result of this. So we'll just have to stay tuned and see. But now they're going to go into the oath part. And what the main thing here is going to be that Fani Willis took an oath in part that she would not take any other compensation for the services she provided to the county. So let's continue on with it.
Any unlawful compensation?
Yes, she did that. And then she also filed some disclosure forms that are required. There's financial disclosure forms that Fulton County requires that you file every year. And you have to disclose if you've received any gift over $100. So from anybody doing business with the county. And Fulton County is I used to be a Fulton County employee. They are very strict on those types of things. So anytime there's anything that could be construed as a gift over $100. And I've gone to lunch with prosecutors before who wouldn't let me pay for lunch because they're like, what if it's over $100, So people do take that pretty seriously.
So that would apply to Miss Willis would not be allowed to receive gifts from whom?
From anybody who was, and I actually believe I attached it as an exhibit. It's basically anybody who is doing business or seeking to do business with Fulton County. Okay. So, and it's one of those.
That would include Mr. Wade, obviously, then.
Oh, definitely.
Okay.
And that makes sense because that's one of those provisions that's supposed to, be guarding against honest services.
Like anti-kickback statute.
That's exactly what
hire somebody as a vendor and they give you gifts in exchange.
What we call honest service.
Yes, and so they require that you disclose that every year. It's signed under oath. You have to file it with Fulton County.
So how'd you learn about this relationship between Mr. Wade? I think this.
Now, this is where it gets good. I've been promising that it gets good. We've had a lot of issues. We're trying to fill in the blanks. So we're going to slow roll this because it is extremely interesting how she gets all this information. And pay attention to Bradley, how he helped her originally, because we're going to talk about this. This gets really good. Here we go.
Has been acknowledged now by both parties, correct?
It has, yes.
It's a dispute as to when it began, but it's acknowledged that they had I don't know if they still do, but at least had a romantic relationship.
Yes, that's
How'd you figure that out? How'd you find out?
So at first, I knew Mr. Wade and I knew Miss Willis, and a lot of people in the community were a little surprised to see Nathan, Mr. Wade handling this case. It was just, a lot of people said that. And so a lot of people were talking about that. And it was kind of surprising because it's not really, he does a lot of law practice, but this isn't what you would imagine him doing.
Did you ever see him have other billings? How do you have time to represent anybody else when he's billing, 24 hours a day to Fulton County?
He had other people working for him. Like he had a law student working for him for a while, and then he had a first year associate. So I'm assuming that they would probably do whatever other work he had.
Did you ever look at his calendar? Did you have access to that to see if it matched up?
No, I didn't have access to his calendar, and I didn't have access to their text messages. I mean, I was able to get his geolocation data through subpoena, but the one thing that really struck me is if I was accused of something and I was saying I didn't do it, I would download my phone. They have a system. It's called Celebrate, and Fulton County pays for it. City of Atlanta pays for it. It's literally a system that you can hook your phone into. I have an investigator that has it, and I have my clients do it all the time. You hook your phone up, and it can find deleted text. It can find everything, and you can limit it. You can say, I only want texts with this person. So if I was being accused of having an affair with someone, and I said it didn't start until April, and someone else said it started in October, the easiest thing to do is to, download that phone.
Remember this about your cell phones, folks. We've talked about this many times. These cell phones track everything you do, where you go, what you're looking at, what you type. Even if you delete your phone, it does not matter.
And for privacy concerns, you can file it under seal, but you could easily narrow it down and say, I want this timeline. I want all of our texts from, November 2021, and it would easily tell whether or not they were romantic in nature.
Before I leave the billing issues, did you ever compare Floyd and Cross's bills to Wade's to see if they were billing a meeting together? Like there was that meeting with teams or what? Were they billing for the same meetings as well?
So I looked at that. One thing is we don't have most of Floyd's. So Floyd has not billed in quite some time. So I didn't have his to compare, but I did look at Anna Cross's. The one day that I remember looking at was when they were in federal court to see, because so Ms. Cross was the one actually litigating in federal court. But Mr. Wade was sitting there with them at council table, and they both billed for that. I wanted to see if he billed for time that he was sitting in court waiting, because I know in Cobb County, for example, with appointed work, if we're sitting in court waiting, we can't bill unless we're actually doing something. Like they won't pay for two people to sit there. And so I wanted to look at that, but they were both there in court. that day.
What about the teams meeting where he billed for? Were either of them involved in that team since they're also outside special counsel?
No, they were not. So all of those people were people who would not have itemized that.
Okay.
Employees.
Back to your uncovering the relationship.
Yes,
How did you figure it out?
So Terrence Bradley was Nathan Wade's law partner originally, and he was also his lawyer in the divorce. I did not at the time know that they had filed for divorce. I knew Nathan's wife. I knew both of them historically from Cobb County. I mean, they're, people knew them in Cobb County. Mr. Bradley actually called me after an article. We were looking into the financial irregularities. We're looking into how much money had been paid because everybody in the case was kind of like, what, why do you have special counsel on this case? Yeah. Like,
was
why
Bradley still a partner with Wade at that time?
He was not. There was testimony that their partnership ended in summer of 2023. So it had just ended, is my understanding. And it's, it's kind of unclear, like what month. The testimony is very unclear as to when they actually, I have when they dissolved. I think it was September, but it's very unclear as to their partnership. And I will say their partnership was a loose partnership. They had a partnership with the bar, but they all had separate legal entities. So each of them were filed as the law office of Terrence Bradley, law office of Nathan Wade. They had some joint bank accounts, but then they had some separate bank accounts. So I don't really know the exact structure. It was a very loose type of organization, but they were working together. And so Terrence actually called me. He had seen an article where I had done open records with another lawyer, Manny Aurora, and we had uncovered how much money everybody had made. The news had gotten wind of that. And I later learned that the news had open records to get all of my open records. So every time I would get something, the news would get it. Because I wondered how that happened. But so that somebody published that. And I had done some more open records. And Miss Willis actually called Mr. Bradley when I did these open records and said, they're looking into us. And he called me because he was worried about it. And so we had a conversation, and he actually asked me, do I need a lawyer? What's going on? What are you investigating? What's the parameters of this? And we had a conversation, and I said, well, my interests are different than yours. I represent Mr. Roman, so I can't advise you. That would be a conflict. He asked if John, my husband, could, and I said, no, that's a conflict too. If you feel like you need somebody, you need to talk to someone else. At the time, that was early in September. I had court in Cobb County, and I ran into Mr. Bradley. I was in Judge Harris's courtroom. I think it was either September 11th or 13th. I checked my calendar a week or so ago, but it was one of those dates. And I was taking a plea in front of Judge Harris, and Mr. Bradley was also there. Another lawyer who ultimately represented Mr. Bradley at our hearing, BC Chopra, he was there in court also. And then a friend of all of ours, who's a district attorney, his name is Bert Cohen, he was taking the plea with me. And Bert and I have known each other for a long time. Terrence, BC, everybody's known each other for a long time. We were all sitting in a conference room attached to that courtroom, waiting for the pleas to.
Give it 1 second. They just popped out on this. It will return in 1 second. Where did it pop out there? Let me see where they're at here. I think they split it up into a separate one. Give me 1 second. They clicked out.
Honest.
Sometimes you have little glitches. Give me 1 second. I'm going to pop it
the
right
involved
back
officer, so Miss Willis, knows or
here we go.
Case, because he took employment later on. He wasn't actually paid hourly. He was a member of Prosecuting Attorneys Council. And I'm glad you brought that up, because that was one thing that I didn't really go into earlier. The other way that counsel is usually appointed in these cases is the Prosecuting Attorneys Council actually appoints it. And that's what happened in that case. But they sometimes will pay an hourly rate if it's something that is needed. But in that case, he was actually the district attorney in another county. And that's what I've experienced before. So the 2 times I've had special counsel, it's been because it's somebody from outside in another jurisdiction that's brought in. So that's what happened in this case. But then he took a job later. The other big difference with that case, and this came up in our oral arguments with the judge, that's a post-conviction case. The standard of review is very different post-trial than it is pre-trial. We're in a pre-trial posture. And we talked about that because the judge asked us a similar question about how to distinguish that. That's the big issue.
Give me 1 second. We're going to make sure I got the right mark here.
Worth versus State. It clearly says.
We're going to back up because this is when she starts getting crossed. So let me back up to where we were, because we don't want to miss all that. That's good stuff.
Then changed.
Okay. So you're waiting on
Okay, we're about to get right back
the
to
people that were not even recommended, or
My
at least your client.
my client. Yes,
Okay.
she added him. So he was one of the ones. So there were some people, you know, and it's publicly available in that book, like Senator Graham, Loeffler, those.
Okay, hang on. She's talking about that book. We're not going to miss any of that. But here's the text messages. Good. I got it. We're going to be right back. Bear with me. Okay, that's the Hawk software. That's going to be that other cell service that I was telling everybody about. I don't know why this thing skipped.
Were the
on
ones
us,
that
but
had access.
it happens.
And he essentially just left her after meeting.
Okay, that's about his wife.
Billed
and
for that. I
leaving
wanted
her.
to see if he billed for time that he was sitting in court.
Okay, this is
waiting.
where we're at. We're going to fast
because I know
forward just a
in
digit.
Cobb County, for example, with appointed work, if we're sitting in court waiting, we can't bill unless we're actually doing something. Like they won't pay for two people to sit there.
Okay,
And
this
so I
is
wanted to
roughly
look at
where we
that.
were.
But they were both there in court that day.
What about the teams meeting where he billed for? Were either of them involved in that team since they're also outside special counsel?
No, they were not. So all of those people were people who would not itemize that.
Okay.
Employees.
Back to your uncovering the relationship.
Yes.
How did you figure it out?
So
Here we go. Here we
so
go.
Terrence Bradley was Nathan Wade's law partner originally, and he was also his lawyer in the divorce. I did not at the time know that they had filed for divorce. I knew Nathan's wife. I knew both of them historically from Cobb County. I mean, you know,
Here we go.
people knew them in Cobb County. Mr. Bradley actually called me after an article. We were looking into the financial irregularities. We're looking into how much.
Okay, just so we're clear, I want to make sure everybody's on the same page. The chair asked a very good question, a very straightforward, pertinent question. How did you find out about all this? I have speculated she started getting the records online, and apparently that did start some of it because she was looking into any type of financial improprieties pertaining to this case. That's what she started out looking. And then Terrence Bradley read about the investigation and whatever was going on in the paper. So he starts getting nervous. He picks up the phone and calls Ashley and said, "Hey, what's going on?" Basically, he's fishing her. He's like, "Hey, I'm getting a little concerned. Do I need an attorney myself?" And she's like, "Well, you know, I can't advise you. I don't want to have a conflict myself. If you feel like you need one, you need to get one." And they just basically started talking, and she's going to explain the rest of it. But the bottom line is you're going to see a ton of this information come directly from his ex-law partner, Terrence Bradley. And I'm conflating a lot of issues here, but it's always been my humble opinion. What happened originally is that when Terrence Bradley basically contacted Ashley Merchant, he was mad because we just found out from this testimony that sometime during the summer 2023, they were mad. So this is brand new. It's not old. It hasn't even been a year. He has an axe to grind with Nathan Wade. He was let go from the Wade's law firm or their partnership. It was essentially dissolved. He was sent packing. He was essentially sleeping with the people in the office, the ladies in the office. He was doing stuff you shouldn't be doing with employees that are underneath you. One particular employee made an allegation of a sexual assault, and that was the end of their relationship. And my theory is that he was mad, had an axe to grind. He reaches out to Ashley Merchant, and here we go.
Money had been paid because everybody in the case was kind of like, "What? You know, why do you have
On
special
this
counsel
case?
on this case?" Yeah, like
Was
why are
Bradley still a partner with Wade at that time?
he was not. There was testimony that their partnership ended in summer of 2023.
Exactly.
So it had just ended, is my understanding. And it's, you know, it's kind of unclear, like what month. The testimony is very unclear as to when they actually, I have when they dissolved, I think it was September, but it's very unclear as to their partnership. And I will say their partnership was a loose partnership. They had a partnership with the bar, but they all had separate legal entities. So each of them were filed as the law office of Terrence Bradley, law office of Nathan Wade. They had some joint bank accounts, but then they had some separate bank accounts. So I don't really know the exact structure. It was a very loose type of organization, but they were working together. And so Terrence actually called me. He had seen an article where I had done open records with another lawyer, Manny Aurora, and we had uncovered how much money everybody had made. The news had gotten wind of that. And I later learned that the news had open records to get all of my open records. So every time I would get something, the news would get it. Because I wondered how that happened. But so that somebody published that. And I had done some more open records. And Miss Willis actually called Mr. Bradley when I did these open records and said, "They're looking into us." And he called me because he was worried about it.
Right.
And so we had a conversation, and he actually asked me, "Do I need a lawyer?" what's going on? What are you investigating? What's the parameters of this? And we had a conversation, and I said, well, my interests are different than yours. I represent Mr. Roman, so I can't advise you. That would be a conflict. He asked if John, my husband, could, and I said, no, that's a conflict too. If you feel like you need somebody, you need to talk to someone else. At the time, that was early in September. I had court in Cobb County, and I ran into Mr. Bradley. I was in Judge Harris's courtroom. I think it was either September 11th or 13th. I checked my calendar a week or so ago, but it was one of those dates. And I was taking a plea in front of Judge Harris, and Mr. Bradley was also there. Another lawyer who ultimately represented Mr. Bradley at our hearing, B.C. Chopra, he was there in court also. And then a friend of all of ours, who's a district attorney, his name is Bert Cohen, he was taking the plea with me. And Bert and I have known each other.
Does anybody have any doubt now what I've been talking about, that all these attorneys know each other? These people are all colleagues. So when you see Judge Scott basically donating $150 to Ashley Merchant or vice versa, it's no big deal. These people do this type of stuff all the time because they're colleagues. She just rattled off 5, 6, 7 different attorneys right there. So long story short, it's very common. Just kind of think about that as we're going through this.
Each other for a long time. Terrence, BC, everybody's known each other for a long time. We were all sitting in a conference room attached to that courtroom, waiting for the pleas, chit-chatting, took the plea, went back in, and Mr. Bradley essentially went through the whole thing and said, well, this is what's really happening. I had a notepad, and I took notes on all the things to ask for open records.
So what did he say was really happening when he said, this is what's happening?
He said that they met at a judicial conference before. He was very specific that it was before she became DA, because that was one of the things that he couldn't remember when the judicial conference was, but he knew that it was before she became DA.
When did she become DA?
She became DA in it would have been January 2021.
Okay.
So she became DA January 1st, 2021, but she had a transition team leading up.
And that fits perfectly with witness. Remember the first witness that was the ex-best friend, the college roommate of Fani Willis. The lady's name was Yeartree. The first witness was, Robin Yeartie, however you say Yeartie. She said exactly what Ashley Merchant is repeating that was told to her originally by Terrence Bradley before their relationship was before she become a judge in South Fulton. And by the way, a judgeship there, if my recollection is correct, is basically minor misdemeanor type cases. But irrespective of that, the year before, of course, we're talking 2019, 2020, it's very consistent with what everybody has been saying as far as the time of the relationship and the nature of the relationship.
Up to that. So, and Mr. Wade was in charge of her transition team. So Mr. Bradley told me all of that. We met for about an hour. Said that they had been together. They met at this conference. Nathan was still married. And Mr. Bradley was upset because of what happened in the divorce. He was upset because they were still married, the Wades were still married, and he essentially just left.
This is one of the new things that I think is a breaking news type of thing. I have never heard of this. It's the first time. She said the reason that Bradley came forward with this information originally was because essentially he was upset morally. He was upset that Wade essentially hooked up with Willis at this conference, and yet he had a wife at home. So it offended his sensitivities, which I don't know what I believe about that, but that was something new, and I haven't heard that before.
Left her after meeting Miss Willis and dropping the kids off at college.
Yeah, and make sure you understand this too. This is good stuff right here. She says Bradley told her that not only did he hook up with Willis at this conference when they first met, which of course Willis was really upset about that revelation coming out. She says Bradley told her he was upset because of the relationship, one, and number two, as soon as his kids literally were dropped off at college, he immediately said, I'm leaving you, to his wife of 20 some years. I'm out of here. And that's when the divorce started. That's really paints Nathan Wade in a nasty, nasty light.
So,
and Bradley was Wade's attorney in that divorce action you're talking about? Okay.
Yes, I didn't know that at the time.
But they were law partners.
They had been,
Okay.
yes.
Okay.
And I actually don't know if he was still his attorney when he talked to me. I don't know if he was or not.
All right.
because at some point Mr. Wade represented himself and then he hired a different lawyer. So I didn't know anything about the divorce at that time.
So Bradley did not like the way Wade had treated his wife,
He did not.
That's right.
but he
did not.
represented him.
He did not like the
Okay.
way he had treated his wife. He didn't like what was happening in the divorce proceeding. Yes.
Okay.
And I mean, I remember specifically him saying, you know, I handle my business, things like that. Like, you know, that I don't leave my wife without alimony because this, and we talked about it. I mean, Miss Wade had been a stay-at-home mom for, you know, they'd been married almost 30 years. And literally it was right after they dropped their youngest off at college that he said, move out, you know? And so we went through, you know, I was obviously interested in, wait, what's happening? Walk me through this. And so he was telling me about the access cards, you know, that Mr. Wade had access cards, telling me about the contracts, told me about their contract, that they had that Nathan had brought them the contract for the first appearance hearings. They had a contract for that. We didn't talk about that yet. That they had the contract for the taint work, and then ultimately that Nathan was hired as the attorney on this case. That they had been dating before, and he told me, you know, they met at hotels. He would go to her place. And I remember him saying, you need to find her bestie who they had a falling out. That's the person whose condo it was that they would meet at. And
did you later determine who that bestie was?
Yes, it was Robin Yeardy. It was not until sometime later that I determined that. It was very difficult to determine who that was because he did not remember her name.
So as it turns out, it was Terrence Bradley that really got all of this rolling with his many conversations and interactions with this attorney, Ashley Merchant. And I don't know if you guys agree with me or not. You can put it in the comments and let me know. I kind of get the impression throughout all this that, in my humble opinion, Terrence Bradley is flirting with Ashley Merchant, which of course I understand that. However, she is married. So if he is offended that Wade and Willis got together when Wade was already, or I should say was still married, and that offended his sensitivity, why would he be acting like this with Ashley Merchant? It just strikes me as odd, their interaction and their text messages. But let me know if you agree.
He knew her by sight.
He did.
Did he later confirm to you or identify who she was?
Yes. So I had sent him a couple pictures or showed him a couple pictures of some other folks or
This
names.
was in January of 24, right
Yes.
before your motion.
It was. It may have even been after I filed the motion. It was around the time. It was either before or around the time, but it was in January. I had gotten some open records requests from the DA's office. They had a contract. Yep.
We just put on screen
There it is.
some of the
Perfect.
text messages that you produced to us.
Yes.
There we go.
This
Yes.
is from your phone.
It is. And so
you're talking to Terrence Bradley, I see over there on.
Let's take a quick peek at this. This is the text messages here. Let's see if I can read this on my screen. It's Ashley Merchant. Apparently she had two phones, one phone for this type of thing and another phone, which is probably a good idea. So anyway, here's Ashley Merchant getting the information pertaining to Robin Yearty. And she goes, Robin Bryant, because that was the maiden name, I'm assuming, of Robin Yearty. And then she also says East Point connection, because remember, Robin Yearty, we'll just go with Yearty, her maiden name is apparently Bryant, was the ex-best friend, college roommate of DA Fani Willis, and DA Fani Willis rented a place, a room, a house from Yearty, which has become the de facto love nest of the lovers, paramour individuals, Nathan Wade and Fani Willis. So Terrence said, send me a pic, because what it was is Ashley Merchant was doing some digging, trying to find out who this woman was that Terrence Bradley told her, you need to find this woman because she would have information and proof of the relationship between Fani Willis and Nathan Wade way before the November 1st, 2021 time frame. Remember, I said that November 1st, 2021 time is absolutely critical, because anything before that is fraud on the court and it is perjury. The same thing that they are currently trying many of the defendants for right now in this so-called RICO case is the same conduct that Fani Willis and Nathan Wade are being charged with. So Terrence says, well, send me a pic. Let me look at her. So she sends the picture. You can see it says file attachment. She's got the name listed as Robin Bryant Yearty. So maybe it's her middle name, maiden name, whatever. And Ashley goes, does Fani know about the Sonia Allen affair? And we'll see what the next one. Oh, I can read it down there. It says, yes, this is her. That's the East Point apartment person. Boom. He's really going the extra mile to help out here. So just kind of keep that in mind.
On the left.
Yes. And so when you see on the 14th, that one that's right in the middle that says file attachment with MIME type, that is a picture of her.
Right.
So it doesn't show up on this, but it's actually, there's a picture of
So
Miss
while
Willis.
you're texting, you're shooting him a picture to see if he can identify Robin Yeardy.
Yes. Yes.
Did he identify her?
He did. Yes. He said, yes, that's her. That's the East Point. And he thought the apartment was in East Point. I later found out it was in Hapeville, but those are very
Right.
close in close areas.
So he knew they would meet at that apartment?
He did. Yes. He knew all
Okay.
about it. And it was hard to find Miss Yeardy. What happened, and she was Robin Bryant, and then she got married and was Yeardy. I did an open records request for a contract that the DA's office got. It's called critical mention. She has I guess he's an attorney, but he's sort of in charge of communications. His name is Jeff DeSantis. He, right after Miss Willis had opened the investigation in this.
Oh, this is going to get good. We just heard the name Jeff DeSantis. Remember Jeff DeSantis? A quick recount. Okay, now it's not Governor DeSantis here in the great state of Florida. We're not talking about this DeSantis. We're talking about Jeff DeSantis, aka the alleged plant inside the DA Fani Willis office, put there by none other than your president, Joe Biden, and his administration. If the reports are true, he is a very high-powered political Democratic operative, has no business being in this office, but boom, his name is now appearing in this particular case for the first time that I know of, other than the alleged plant allegation. But let's see exactly what they talk about pertaining to Jeff DeSantis, aka the plant, and let's see what she has to say.
Case that same week, he contracted a company called Critical Mention, which is a media monitoring company. They put a dollar figure basically on your media presence, and they give you these analytical reports, and they say, hey, you did great on MSNBC. That's $1 million worth of stuff for your brand. The Fani Willis brand is doing well, or
Now you guys hop on over to Critical Mention later and see if your name's worth anything on the social media sites.
or this phrase is doing well, things like that.
She had an employee in her office that was responsible for promoting her image, her publicity.
She had a publicly funded contract for this. So Jeff DeSantis contracted or called this company, and it's in the emails. I think I provided those as well, but contacted Critical Mention and said, we need to hire you to do media monitoring. And it was the same week that she had sent the letter to Raffensperger and Kemp about this case. Said, we need to have a contract to do media monitoring. Got $10,000 approved, paid $10,000 for a year contract for an annual contract.
Who approved that?
Jeff DeSantis's email said the county approved it, and his emails indicated that it was hard to get approved, that he had to really push, I think is what he said. There's some language to that, but the county paid for it.
Do other DAs do that?
I've never even heard of.
Yeah, well, of course, Jeff DeSantis, he's got a ton of money that he's been paid, and he's getting money from, allegedly, the Biden administration. So, miracle of miracles, he's got tons of money to help fund this charade going on.
Media monitoring. I didn't even know it
Yeah.
existed. No, it was very shocking. But so I got some of the emails about this media monitoring. So I did open records, and again, once I got them, they shut me down and wouldn't give me anything else. But so these emails have attachments, they're PDFs, and you can see in the emails the hyperlink to them where you can actually see the analytical reports. That's what I wanted to get, and obviously nobody would give those to me. But these emails showed a trail where two people in her office, so Miss Willis, Mr. DeSantis, and then Robin Yeardy, were the ones that had access to this Critical Mention profile. It's a platform that you can log into and see, how am I doing in the media.
What was Robin Yeardy's role in the DA's office?
She was a liaison between the news organizations. So she said that when CNN, MSNBC wanted her on, they would call Robin and she would coordinate it. She would do her hair and makeup, and then she would coordinate her interviews. But so how I found Robin was I'm going through these emails, and all of a sudden I see an email from Mr. DeSantis saying, take Robin off of this account. She's no longer with the office. And I was like, oh, I wonder if that's her. And so I found a picture of her and I asked Terrence, is that her? Because I found out she had been fired or been let.
Boy, I tell you what, if I ever get in trouble, especially in the state of Georgia, I want this attorney on my case. This woman's tenacious. She drills, she digs, she doesn't give up. She puts the dots together. She loves this kind of like forensic type legal work. I love it, and I love her. What a great, great attorney.
go or had quit or whatever it was. And so that's how I was able to figure out who Robin Yeardy was. Then we were able to run her information, get an address. And that's how we were able to narrow down where this Hapeville condo was.
Okay, so that's where basically Miss Willis and Mr. Wade would meet for their relationship.
Yes.
Yeah.
But Mr. Bradley told me at that first meeting that they would meet at hotels. He told me about a lot of travel. I mean, he detailed, he detailed a lot of stuff. He said that they traveled to Texas, they traveled to Florida, just, a lot of different travel. He said Belize. He specifically said Belize, a cruise, the Bahamas, things like that.
And you were later able to verify that through other subpoenas or open records request or whatever?
Yes, I was. I was able to, I subpoenaed bank records, I subpoenaed credit card records, and then I actually subpoenaed the travel agencies that Mr. Wade used for some of those trips. He used 2 of the cruises that they took, he used a travel agency. So there was a cruise to the Bahamas. I got through a travel agency. There was a trip to Aruba that I got through the travel agency. And then there was another cruise, I think that one was to the Bahamas also, that I got through a different travel agency. And then his credit cards are the ones that showed all the Belize trips.
And they showed that he was buying the tickets for both himself and Miss Willis.
Oh, yes. The credit card statements. So because I guess he used a travel agency, his credit card statements actually had her name and seat number and all that on it.
Wow.
Okay,
So, there was no disputing.
Clear it was paid for by him on his credit cards?
Yes. Oh, yes.
Is this the document you gave us from the Capital One there?
It is. Yes. And there you can see. So Clara Bowman is Mr. Wade's mom. So this was the cruise that happened October 31st, around that date. Mr. Wade.
Man, look at all the documentation they got on these people here. You even have the mom of Nathan Wade. You have the American Express account numbers, or at least the transaction number. And you can see, I don't know if you can see it clear on your screen right there, but they have it all listed right here. The alleged rent-a-cars. He's got an Audi for $6,014. A lot of this she'll go on and testify that she did not include in her findings because she wanted to be absolutely certain that it was related to D.A. Willis. For example, a lot of the Uber travels, she knows intelligently that they had to be related to their vacation, to their trip. However, she didn't want to assume anything. She wanted to make sure she had everything nailed down properly, which is good advice to herself because, after all, she's in defense de facto of the President of the United States. So good for her.
Paid for Miss Willis, Mr. Wade, and then his mother's plane tickets, and then also their cruise receipt. I think that one was Royal Caribbean.
Okay. So your summary here showing the trips, we know that in late October, they took a cruise to the Bahamas, and this is from his financial records. He paid for this for both tickets.
Folks, take a look at this. She lays it out right here. Let me remove this comment here. Look at this right here. I mean, it is all laid out. You have October 28th through 31st, 2022, a Royal Bahamian cruise for $33.35. You got November, so you got October. I mean, they literally went from the cruise line to Aruba. Let's see, October, November. Yeah, so next month for another $44.53. And then the next month after that, in December 30th, they're on a Norwegian cruise. I thought they'd be back at the office prosecuting this case against Donald Trump. Fast forward 3 months later, you got March 18 through the 22nd of 2023. They're on the way to Belize for $27.94. And then May, so you got March, April, May, 2 more months, another 60 days or less. They're in Napa Valley, California, probably having a nice drink with Nancy Pelosi or something out there, I guess. I mean, just take your pick as far as California. I've heard innuendo on the internet that that's where Nancy Pelosi's based out of, but I don't know. But I'm sure they're out there just whining and dining, laughing, enjoying all the comforts of the Napa Valley, just enjoying the taxpayers' money of Fulton County and the COVID tax dollars of you.
Yes, this is from his financial records. And I tried to be, there were a lot of Ubers and things like that. I did not include things like that, I wasn't positive. I wanted to be under inclusive, not over inclusive.
Right. And then you show the trip to Aruba, another one to Bahamas, one to Belize, one to Napa Valley, California. Yes. These are all from October 22 up till May of 23.
Yes.
Okay. This is a document you produced us?
Yes.
This summary, is this something we prepared?
No, it's a summary.
Okay. And so you discovered that and verified its accuracy through these credit card receipts, et cetera?
Yes. Oh, yes.
Okay. Do either of them deny these trips occurred?
No, not at all.
And so is this the impropriety, the financial impropriety of getting financial benefit from the job, that he's paying for her way on these trips with money
Yes.
that she's paying him and approving?
This is the what I would call undisputed. You know, the some of the other stuff on his credit cards, it looks like there's trips to Charlotte and Florida and other things like that. But this is what we could undisputed say was with Miss Willis.
So back to you're a good investigative reporter here. So you have heard these rumors, and now Mr. Bradley, just by almost happenstance, you're with him in court.
Yes.
And he spills the beans on it and verifies it. Then you go get the documents to prove it's accurate.
Yes.
And you identify year to get him to say, yeah, that's the woman whose condominium they would go to.
Yes.
Okay.
And you know, I developed it. You joke about my investigative skills. I've done public defense most of my career, you know, at some point or another, pro bono. It's hard to get money for investigators. So I've learned how to do a lot of it on my own. And, you know, I dig a lot on things. So, and I do like to use the Open Records Act. So I was able to do that and get a lot of information. But what I did was I compiled all of the information Mr. Bradley gave me, and then I did various open records requests based on it. And then, you know, once I would get something, I would reach out to him to verify, because I wanted to make sure that I wasn't tracking anything that was wrong.
Okay.
You know, I didn't want to make any allegations that didn't have support. So I would regularly verify with him. And I'd see him in court. We talked on the phone several times. I wasn't the only person that he told about this. There was another attorney on the case, Manny Aurora, who his client ultimately pled out. So he didn't continue this.
Remember, Manny Aurora is now the second witness that has come forward since this particular hearing is being taken under advisement, essentially, by Judge McAfee. So the first one was the Cobb County solicitor the other day, that Cindy, whatever her name was, Cindy such and such. Well, you have Manny Aurora, who is another attorney that was handling the case for one of the other defendants. He has come forward with personal knowledge, as you have attorney Ashley Merchant describing right now. So I just want to make sure you keep the players in this saga together, because I don't want to get confusing, but it is imploding on Fani.
This investigation, but he was involved in the investigation early on. And Mr. Bradley told him some of the same things that he told me. So, you know, I was able to independently verify a lot of things, which to me, investigating is important. You know, that the East Point location, that it was in Hateville. You know, Robin Yeardy actually did quit. You know, Mr. Bradley had told me.
Was she forced to quit, or what? How'd that come
No,
about? You know?
I don't believe she was forced to quit. That was a point of contention in our hearing. She said she left, that she was sent to another division. It's my understanding she had some, she was outspoken about, she didn't like some of the things that was happening in that office. And when she voiced that, she was sent to a different department to work, and it wasn't something that she wanted to do, because she did the communications. And so she quit after that, is my understanding.
Okay.
Based on her testimony and, you know, the allegations and all the pleadings.
All right. So after, I might be skipping parts of your investigation because it's pretty darn thorough, and you had gotten this Trackhawk, or Cell Hawk, what's it called, where you're tracking the
Yes.
location. You were mentioning to me earlier, when I kind of got you off, that employees can have it on their own phone if they want to, and she could have gone back and proven that they had not been communicating before he was hired.
Yes.
Okay.
So let me explain that, because there's two different systems, and, you know, I'm always learning new things about this, but cell phone data is one of the new things in criminal defense. We see it in a lot of cases. The CellHawk data that you just showed, that is geolocation data. That is different from the Cellbrite. So there's two different programs. CellHawk is the program that does geolocation data. Essentially what you do is you get all of the pings. So every time your phone, you know, you see those cell phone towers everywhere. Every time you use your phone, it's trying to find the closest tower. So in a metro area like this, there's a lot of towers. That's why we get good signals. So when he's in Hateville, there's a lot of towers. So we can really, really narrow it down. So what we had our investigator do, and I'm only talking about the geolocation stuff, I'll talk about the text in a minute, but what we had our investigator do was narrow it down. We got all the raw data, and we had him narrow down, and we actually excluded a ton of things that were not right on top of this location. Like, we wanted to be very, very careful just to have what was literally right on top of this location. So he created a geolocation fence, which
The location you're talking about is Miss Yeardy's condo.
yes,
Okay.
it is Miss Yeardy's condo, that area. So he was able to find, essentially, just to summarize a couple of the things, where he, Mr. Wade would call Miss Willis at midnight, something like that. And then all of a sudden his phone would travel, and you can actually watch it. When you do the live Cellhawk, the app, it's pretty cool. You can actually watch the phone travel, and it's pinging because you're using it. If you have an app open, your phone's pinging. So my phone's pinging right now because I'm sure I have an app open. So it's pinging from his house all the way down to the condo at midnight, 1 a.m. And he calls her when he gets there. And then it goes silent for 4 or 5 hours. And then, early in the morning hours, he starts pinging again, driving back, and then he texts her when he gets home. So,
and this is before he gets hired in November of 21.
Yes.
Okay.
So, and there's a couple different ones, and I would defer to the experts on the Cellhawk data, but that's the summaries based on what we had him do. And again, we try to be very, very narrow. There were a lot of dates that it looked like it had happened also, but maybe he was bouncing off a different location. And so we wanted to be very narrow.
So is that why y'all asked him in the hearing, how many times had you been to this location? I mean, you already kind of had the date on him.
Well, so that's an interesting point. All we have as defense lawyers is the right to subpoena evidence. I have to have an evidentiary hearing to do that. I could not issue a subpoena for AT&T for this evidence until I had a hearing date. So, and it takes a while to get this stuff. We got it that morning. So, the morning of the hearing, and obviously I'm kind of busy doing the hearing. We got that data. My paralegal was literally trying to download it for the investigator at the time and get it over. We knew we had the data, but we didn't know what it showed. So at that time, we didn't know, what it showed really until he was able to do the analysis. We had some preliminary reports from him, but nothing. I mean, it took a lot of hours. It's a lot of data. So it takes a lot of time to pinpoint this information.
Yeah.
But the other thing that I was talking about, so this is the Cellhawk report, and heat map is just like how many times it's pinging, heavy concentration is, you're talking a lot at this time, or you're at that location a lot. There's a lot of usage.
Wow, that's really interesting, ain't it? Nowadays with these cell phones, these things can incriminate you if you are committing a crime. I guess it's good because they could also exonerate you perhaps, but this is extremely compelling evidence during the period of records in 2021, which is January 1st, 21 through 11/30/2020. So there's going to be just about 30 days of overlap, because remember, the key date is November 1st, 2021, when Nathan Wade originally inked the special prosecutor deal with Fulton County. It says here approximately 12,000 interactions of voice plus text in this period of 2021, 2,073 voice calls. How do you talk to your lover that much? I don't understand that. And then 9,792 text messages. We knew it was roughly 10,000 text messages. Unbelievable. Well, it is what it is, right?
The other thing I was talking about, just to make sure it's clear, so that's Cellhawk. Cellbrite is a different program. Cellbrite, and it's CELLEBRITE. Cellbrite is a program similar to Cellhawk, but it downloads data in the phone. So like this one is you pinging off of towers. It's geolocation.
Showing where you were.
Exactly.
At a certain time.
Cellbrite actually can get your texts, your pictures, your app usage.
Ouch.
I mean, all of that stuff. So it's one of those things that if you want, if a defendant is threatening someone by text and they delete it, they'll take their phone and hook it up to Cellbrite. Cellbrite it makes what's called a forensic copy of the phone, but you can also limit the data. So it's very expensive program. So not a lot of people have it. So when I have my clients use it, it costs a lot of money for them to have it done. But the DA's office has it. They have the software. They pay for it. You can find that in their open checkbook. The city of Atlanta police have it as well. But what you can do is you can copy cell phone. So what I had mentioned earlier is
you have to have the cell phone to do that?
You do. You have to have the cell
So
phone.
what did Mr. Bradley give y'all his cell phone? Or
No.
how'd you get Mr. Wade's cell phone?
So we did not get that data from Mr. Wade. So we only got the geolocation data from Mr. Wade. I do not have the power to get the text messages. I don't have that power. I would have to have a search warrant. The state's the only one that has the power to actually get someone's text messages out of their phone. But my whole point in saying that was if I had been accused of having an affair and it didn't start and I said it started in April and someone else said it started in November. They have the ability. I don't have the ability. They have the ability to plug that phone into the Cellbrite.
Just as a side note, if you're wondering how they got these cell phone records, even Nathan Wade did not understand. And DA Fani Willis was threatening, she was alluding to and threatening criminal charges for anybody that misappropriated or illegally obtained their cell phone records. What both of them didn't know, and these people are supposed to be experts. I was able to find this information out just by a little bit of Google searching, is that in the state of Georgia, it varies state to state, but in the state of Georgia, if you are a duly licensed attorney and you contact AT&T or Verizon, they have essentially an agreement that send them a subpoena, which any lawyer can essentially type up and send over, and they will gladly, immediately and quickly give you whatever cell phone data that you request. Now, as Ashley Merchant's talking about here, you cannot get someone's text messages and pictures and what app they were on, this type of thing, without an actual court order, but you can definitely get the geo pinging information. They do not have a lot of restrictions against that as long as you are, as I said, a licensed attorney.
And print out a report
Right.
that shows all of the texts.
So Mr. Wade and Ms. Willis, had they wanted to disprove your allegations, could have just used that Cellbrite program and it would have shown no communications between them.
Yes. And it would have also showed the contents of the text. If the texts are romantic, if they're not romantic, if they're friendly, and they would control the data. So if there's something that was privileged, they could redact it. If there was something that, if they wanted to only limit it to we want to prove that we weren't talking romantically in November, they could
So
limit
they
it to
could have
that.
actually pulled up the text itself to say, hey, I need you to help me work on this case, or else, hey, I need you to meet me at the Love Nest.
Yes, 100%. Yes. I don't have that ability. So I don't have the ability to get a search warrant and get that data. All I have the ability to do is get that geofencing.
Well, who found out about these 12,000 texts and calls and all that kind of stuff?
That is what I was able to get by subpoena. So I was able to get the geolocation data by subpoena. What I can't get is what's inside of the phone. I can't get the texts inside the phone.
The words in the text.
Exactly.
But you were able to find out that they were texting each other
Oh, yeah.
prior to November 1st of 21.
Yes.
How
And
did you find that data? Is that anything you've produced to us?
that is so the CellHawk data actually analyzes that. So you can see, and we just summarized 2021. So approximately 12,000 interactions, that's voice and texts for the year of 2021. And again, remember 2021, he didn't get the contract until November of that
Right.
year. So most of 2021, he's not under contract. Over 2,000 voice calls, almost 10,000 text messages.
How did they explain that? Did you confront? We're not privy to what all came out in evidence at the hearings that you've had. Did you get either one of them to say, that's not true, we didn't really talk 12,000 times? Or
No, what they did was they filed an affidavit saying that geolocation data is not always reliable.
does that apply to Cellbrite data though?
No, it doesn't. And it was ironic because I have a number of cases. I mean, almost every murder case I've had in the last decade has had geolocation data.
Used by the prosecution against the defendant, right?
They use CellHawk data. I mean, literally, they're using this right now. So our investigator actually analyzed the same. There's a trial going on. It's called the YSL trial. There's the same data being used in that trial, and our investigator actually analyzed it for them in that case. So I mean,
For them, you mean for the Fulton County DA's office?
no, for the defense looking at that data. So the point is, they're currently using the same data in another courtroom to prosecute someone, but their defense in our case was that it's not reliable.
It's not reliable.
Got it. And did your Cellbrite data come in? The existence of the cell phone calls?
No. So the Cellbrite data, that would have to be voluntary on part of the DA to actually
So they could show you that to disprove your allegations?
100%.
Okay, didn't do it?
No.
Neither Wade nor Willis?
No.
Okay. All right, so you've done your investigation. You've determined you think there was a relationship that had begun before he was hired.
Yes.
And after having met with Mr. Bradley,
Mhm.
you began to prepare a motion to disqualify and to dismiss the case altogether, right?
Yes. I actually started the motion
Let me
in
get back on
September.
the cell phone.
and then added to
text
it.
messages. All right, and so then you somehow preserved, you had text communications with Mr. Bradley to confirm this?
Yes.
And was that because you didn't want to file a pleading that was inaccurate?
100%.
You wanted him to verify the accuracy of what you were claiming had happened?
I did not want to say one word that had not been verified.
Because he was the source.
Yes.
He's the guy that was his law partner and his divorce attorney
Yes.
who probably knew as well as anybody in the state.
They had been best
Well,
friends also.
Okay. All right. And so let's pull these up, Senator Dolezal. When did you start? You kept these text messages somehow?
I did. So I actually, Mr. Bradley uses a Android, I believe. And so
Let's take a quick peek at these text messages. These text messages are extremely incriminating and interesting. Again, these are the text messages between Ashley Merchant and Terrence Bradley, the ex-law partner of Nathan Wade. Okay, I just want to make sure we're all straight. So basically, she's about to file this motion back in January pertaining to having DA Willis removed off the case. The motion is called Motion to Remove DA Willis and her office off the case. So she is sending him the motion, and she literally asks, hey, is this accurate? Upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. And Terrence Bradley goes, no, it was at municipal court, which, he's critiquing exactly. Remember, on the stand, he said he was speculating. This doesn't sound like speculation, right, folks? So Merchant responds, oh, thank you. Then Bradley says, but you can't put where they met. Not many people know that. And then Bradley says, I might be one of only, not even Chris Campbell. So basically what he's saying is, if you put it in there, the specific information, they will know it's me, because there's not many people that know this information, maybe one additional individual. However, at a later chat that we may have an opportunity to look at, he basically says, go ahead and put it in there. I don't really care. Just go ahead and put my name in there. It's no big deal.
it was not easy to just download them, and I'm not the most tech savvy person. There's a lot of texts that just went into things that I thought would just embarrass people and weren't relevant. So what I did was I screenshotted the texts that I thought were relevant. I tried to use those in court, but the prosecutor kept objecting and saying I was hiding things because I wasn't showing all of my text. So they just kept on and on for days saying I was hiding things. And I explained to them, I let them look through my phone. They scrolled through all my texts.
Who's they?
It was Adam Abadi was the prosecutor.
Okay.
So he just.
Okay, do you understand what she's talking about? I just want to make sure we don't lose anybody here. Remember back in court when they were having this hearing, they basically called her a liar and they asked the judge for sanctions against her. Remember this? Really, I could tell that it upset her. It would upset any attorney to have the state prosecution team ask the judge to sanction you and tell everybody in front of the world that essentially you're a liar. You're making this all up. And he kept objecting and saying, well, what was said before this message? What was said after this? Whatever. And all along, what was going on is Ashley Merchant was simply trying not to embarrass people with certain comments or addresses or personal information. That's all it was. And if you remember, she showed Miss Cross on the prosecution side exactly what was on the phone. There was a big fiasco, a big to-do about nothing. All she was trying to do is protect people and their privacy, and it essentially backfired.
Just kept saying, that where's the beginning of that text? Where's the thing after that? Where's the other part of that text? These aren't complete, rule of completeness, kept objecting. And I had just screenshotted the texts that I thought were highly relevant, but weren't slanderous, I guess. I don't even know the word, but there were some that Miss Willis's daughter had failed out, like things like that. They were just ugly. They didn't need to be admitted.
Oh, yeah, I read that.
So I had tried really hard to just screenshot the relevant ones, but they kept saying that I was hiding stuff and I wasn't showing the whole thing. So when they objected to my text coming in the screenshots, they said they wanted the whole text chain, and the judge ordered me to, if I was going to admit the text, to go figure out a way to download all of them. So I bought a program for $20-$30 and took 3 hours.
Just as a quick programming note, if you wonder why I keep lighting up the screen and looking at the bottom, I just want to make sure in case this thing was to crash or to flip out again, I know exactly what the timestamp was that we were at. So I go right back to it, just FYI.
And I was very proud of myself for finally figuring out how to do it. But I was able to make a copy of it and then redact our phone numbers. So this actually showed like when they're read, when they're viewed.
What were you? All right, so up there on January 5th at 9:50 a.m.
Mm-hmm.
You're asking what?
This is the one that I love right here. This particular text message exchange. Merchant says, do you think it started before she hired him? And I want to point out that this is what that small guy, that the individual that didn't sound like he knew what he was doing. We were making a lot of jokes about him at the time, but he was making a big deal about the word think. Do you think it started before she hired him. And the reason why this was a big deal is because Bradley on the stand finally was like, hey, I was just speculating. That was his defense in all this, because of the word think means speculation. And that's what the prosecution was drilling down on. But what the prosecution didn't want to talk about is the very next statement by Terrence Bradley says, absolutely. So it goes like this. Do you think it started before she hired him? Absolutely. That was Bradley's response. Bradley continues. It started when she left the DA's office and was judge in South Fulton County. So that's exactly what the exchange was. I mean, how do you go from that to say, I can't remember nothing? And here at the bottom, you probably can't read it. He says they met at the municipal court CLE conference, which is the continuing education for attorneys. And that was what upset Fani Willis so bad. Was the allegation was they met at the CLE, which is a continuing education type thing. They're probably at the bar having some drinks and they end up in the bed together. And that's what had her all hot and bothered. Well, I don't know if that's the right way to say it, but it had her all upset in court, and she marched in there like a trooper and she wanted to take the stand.
What do you read the question?
So I'm asking him, do you think it started before she hired him?
You're talking about the affair.
Yes, the affair.
And what's his response?
His response was absolutely. It started when she left the DA's office and was judge in South Fulton. And so, these are things that he had told me, but I was getting ready to file. My filing deadline was the 8th. And as we're doing this, I'm fact checking line by line, basically.
Right. So did you send him a copy of your proposed motion?
I did. And I actually admitted, so at the hearing that we had, I was able to admit the email where I sent him that. So I sent him a copy of the motion that weekend when I was I wanted him to review it. And then he had a text. He didn't write me back by email, but I submitted my email so that the court could see exactly when I sent it and when he responded. And then he responded that everything looked good. Because I asked, I said, I'm sending you this motion. I need you to look at it. And then he responded that everything looked good in it. Right. He actually told me at first he wanted me to make some changes because I had not included the information about how much money he had received. I had only included the information about how much Wade had received. And, I didn't know that it wasn't really highly relevant to my motion. But he was like, oh, that's going to tip them off that I'm talking to you. And he did not want anybody to know that he was talking. He was very concerned about what.
I'm going to let you just read through this chain.
Okay.
All right. We left off up there. Absolutely. It began when she was a judge in South Fulton. When was she a judge in South Fulton? She
became a judge in August of 2019. And I did an open records. I first asked, I first did an open records and they said no. So then I subpoenaed the records for the judicial conference, the municipal court conference.
So she was a municipal court judge.
They were both municipal court judges. So I got the
Who's both? You mean Wade was the judge at the time also?
Wade was a judge. He was actually a speaker on the panel. It was October 2019. So I found online an old agenda where he was speaking, and Terrence Bradley had told me that they met at a conference where Wade was speaking and Willis had gone. So I knew that. So and it was in person. So I could narrow it down because of COVID. I figured out when COVID happened and when, all the conferences went virtual, narrowed down my timeline. Wow. So I searched for this specific time period, which is when Bradley had told me the relationship started.
And when was that conference?
It was October 2019. Right. So I found the agenda for that. So then I reached out to the municipal court judges CLE group and said, here's an open records request. I would like
And of course, this October 2019, this is definitely the start of their relationship between Willis and Wade.
List of attendees, because I wanted to verify Miss Willis went there because I was trying to fact check. And they said no. So I subpoenaed them and they gave it to me. I also subpoenaed.
Was she in attendance?
She was.
Where was that conference?
It was at Lake Lanier.
Okay.
I also did an open records request to the city of South Fulton because I know that they have to sign off if your judge is going to go to a conference. So I did an open records request to them to make sure that they had actually sent her to that. So I verified from two different sources that she attended that conference, and that matched what Mr. Bradley had told me.
All right. So is that a part-time job, a municipal court job, a judge?
Yes,
okay.
It is.
So Wade could continue practicing law and do that on the side.
So she was a full-time, but Wade is a part-time, and Wade only did maybe once or twice a month at most.
Okay.
Because he was in the city of Marietta. I mean, he was he was a fill-in judge for that. That wasn't his.
Okay. So you narrowed it down to that's when the relationship began. scroll through here for us, and I can't read that green line. What's
okay.
the next? If you don't mind, just sort of
No,
read
of
us
course.
through.
It says, is this accurate? And this was again on
So when
January.
you're saying, is this accurate? You're going over this brief and saying, I'm about to swear this in court. Will you verify it's accurate?
Yes.
Okay.
So at that time I was going through the actual statement because I was trying to figure out how to say it, and so I said, upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. And he corrected me and said, no, it was municipal court.
You had said magistrate court, and he said no.
Right.
Okay.
And I slipped up. I should have said municipal court. I knew that.
So you say thank you. What was his response after that? No, this is 12 something PM on January 5th as you're getting your pleading ready.
He said, you can't put where they met. Not many people know that. I might be one of only, not even Chris Campbell.
Chris Campbell was their other law partner.
Yes.
Okay.
And I did not disclose Mr. Bradley in my.
Yeah, Chris Campbell. Remember, there was three of them. You had Terrence Bradley, you had Nathan Wade, and Chris Campbell. They were the three law partners of the loosely affiliated law firm.
Initial filing. I didn't until the state forced me to.
Why was he afraid to be disclosed? Just because of his relationship with Wade, or was he afraid of these people, or just didn't want to betray them, or what?
Multiple reasons. I mean, it's the district attorney in Fulton County. I didn't really want to go, file something against her. It's not exactly a fun position to be in. Also, I mean, they have a lot of mutual friends. I'm sure it wasn't a fun position to be in to be outing a friend of yours, but the attacks, I mean, it's a small legal community.
Were you able to get this into court? Because Bradley, I saw some of his testimony, all of a sudden can't remember anything about anything now. Were you able to use this to impeach him and show that he did know precisely what happened and when?
Yes, and he changed his testimony somewhat. At first, when he first testified, he testified that he had never discussed this with me. And
then you showed his text messages where y'all discussed it.
Well, at that point, I that caught me off guard. So, I didn't expect that. So then I pulled my text messages, and I had some screenshots of them just in case. And I told his lawyer, do you want to look at my text messages? And so then he later came back and testified that yes, he had.
Had told you that?
Yes.
Okay. And did Wade testify at any of these hearings?
He did.
Did he acknowledge the relationship or not?
He acknowledged the relationship, yes.
Before he was hired?
No, he did not. So before I filed the motion, nobody acknowledged any relationship. So I filed the motion on January 8th, and then on Martin Luther King.
Walk us through that. What were the grounds why is it you feel like Fani Willis should be disqualified from continuing this prosecution?
Yeah, and so and these are things that I alleged in my initial motion that was filed on January 8th. I outlined this. My client in particular was not part of the special purpose grand jury. They did not recommend him to be indicted. He was not a subject. He wasn't part of that.
Yeah, if you remember, we talked about that extensively, that he was not indicted by the grand jury originally. That's one of the things that is very unique about this particular case. And you can bet that DA Fani Willis wishes heavily that she never heard of Michael Roman, but the grand jury came back and said, no, we're not going to return an indictment against Michael Roman, which is kind of unusual because you've heard the expression before. Anybody, or I should say a DA or a solicitor, you can get a grand jury to indict a ham sandwich. That's the expression as far as lawyers or in lawyer circles. You can get anybody or any grand jury to pretty well do whatever you want. The reality is a grand jury is mainly an investigative tool that gives a DA, a prosecutor, whatever, the ability to bring people in and talk to people under oath or to gather evidence or whatever it is they may need to bring charges against someone. But in relation to Michael Roman, they could not get it to go forward. It was just that simple. But that didn't stop DA Fani Willis. DA Fani Willis, she calls the shots the way she wants to call the shots, and she decided she was going to run him over with the same bus she was going to run everybody else over with. It's really just that simple and just that incredible. I told you this was going to be a interesting hearing, and she lays it out big time. Now, folks, listen, we've been going almost 3 hours, and I love sitting and talking, but I got back issues and other things I'm not even going to mention. I got to get up and stretch, walk around, do whatever. So we'll try to pick it up a little bit later. Make sure you have the bell notification on. When I go live, you'll be the first to know it, and we're going to pick it right back up where we left off right here. So, I always appreciate you joining me. Always tell you, keep that mind free, never give up. And until we join next time, I am J.R. Dukes.